1 second. For admission. Matter for admission for day after tomorrow. Contempt matter, but I had filed in a. It will come.
Malaj, may I
No need to give memo.
Malaj, may I mention an item? It's related to tax, Malaj. GST liability on my employees. I've already filed the writ petition.
See that all matters which are mentioned are listed at appropriate time in accordance with the urgency. Contempt may wait for unless it is so urgent.
Malaj, the department is initiating recovery against me, Malaj. I've already deposited the tax. The amount involved is more than 50 crores, Malaj. The writ was filed on 1st April. But Justice S.R. Krishna is not assembled today. Malaj, if the matter can be taken up at the end of the board, I'll mention its urgency, Malaj, for stay, Malaj, in the interim period, Malaj. Till the time the matter gets listed, Malaj.
Today may not be possible.
Malaj, any other day, Malaj. My accounts will be attached, Malaj. The amount involved is 50 crores. I've already paid the tax. It's about the penalty and interest.
So
and this honorable court.
What is the urgency?
Malaj, department is initiating recovery against me. I've already paid the tax. They are talking about a penalty and interest. Amount involved is 50 crores, Malaj. This honorable court has already seized of the identical issue and granting stay, Malaj.
19th.
Malaj. Malaj, it can be 15th, Malaj.
15th. Lot of matters are there.
Several matters. Single bench matter.
Single bench matter.
Then why
you mention there only?
Malaj, Justice S.R. Krishna is not assembled today, Malaj, the court.
There will be other bench. It's not that court without there will be.
Then mention before the appropriate bench.
Malaj.
Not
before. It appeal fresh matter. The memo for being spoken to, Malaj, there is a small mistake. That is, as on the day order was passed, that mutation entry will be in the name of father. That was given to understand for the open court, Malaj. That
whatever, if he wants to seek review.
Which order?
My lord, this was a judgment passed by this honorable court during the hearing, my lord, with regard to modification of the order. It was mentioned that the father's name would be entered, will be retained instead of
15th. 15th.
My lords, kindly, a matter was mentioned and it was directed to be listed before this court on 4th.
site input.
My lords, kindly, a matter was.
The appellant society has been allotted a site in APMC at Yeshwantpura. Lord, now the APMC director passed an order by forfeiting the land in question, which has been questioned before a learned single judge. Learned single judge dismissed this for a petition, my lord. Hence, there is an extreme urgency in this matter. If they, my lord, they take back the land, my lord, we are any date in next week.
After vacation. After vacation.
Lord, this is a memo for being spoken to, Your Lordship. It's the memo for being spoken to. It was taken up on 2nd of this month, Your Lordship. The Lordships had passed order. It was a case for civil contempt. We had, Your Lordship had suggested to withdraw the case and file for execution. Your Lordship had given liberty to that extent. It has not been recorded in the order sheet, Your Lordship.
15th.
Much obliged.
My lords, kindly.
All being spoken to.
My lords, kindly.
2:30.
My lords, kindly, the matter.
For civil contempt matter, the issue between the parties has already been settled. But then again, my lord, there has been a flouting of the memorandum of settlement wherein my minor daughter has been cut off from any kind of contact with me. As per the memorandum of settlement, my lord, I had to have joint custody and sufficient visitation rights. But then again, my lord, in the last 1 month, have all of these orders have been flouted by the accused herein. And my lord, she is planning to take the child out of the country. Hence, my lord,
Then it will possible only in the week of 15. In the week of 15.
the week of
Seven,
if a
18.
date may be assigned, my lord, if I may request.
18.
18th.
18.
My lord, say request for posting. A matter was directed to be listed on 4th medical admission matters. Unfortunately, the matter came up before another roster bench by mistake on 4th. My colleague is there. I am mentioning the matter, my lord. It was directed to be listed. Medical education matter. 4th, before another roster.
We
It
listed on 15.
grateful, my lord. Grateful.
Plus, is a writ appeal matter which was dismissed for non-prosecution, my lords. I filed an application for recalling the said order.
Then there is no urgent listed. We are not accepting memo for that.
Seeking an adjournment, my lord. Serial number 57, my lord.
57.
I have informed the appellant also. In fact, my lord, I have filed my statement of objection Saturday. That is not put up before this court, my lord.
So beyond vacation, after vacation,
Yes, my lord.
after
The date may be fixed, my lord. after-
date will be given. Give date. 12th of June.
Number 34, my lord. For the appellant.
34.
34, my lord.
Yes.
Senior is not in station, my lord. Kindly after next week, my lord. I informed to the respondent counsel. 34, my lord. Serial number 34. Seeking 1 week for adjournment.
Beyond after vacation.
Please.
Lords, if your lordships kindly, serial number 32, my lords, I appear for the petition.
32.
32. My lords, I've informed the other side the state is appearing. My lords, any date convenient to the court. My lords.
After vacation.
If it is before, it will be convenient, but I'll leave it to your lords.
What is the subject matter?
My lords, this is regarding a deeming fictions operation for extension of mining lease, my lords. Your lordships are hearing it in another matter. I'm aware your
Pending
lordships
consideration.
are.
That is the only,
another
that is the, for
Please.
that purpose, that for that reason only we are keeping this side.
Please, my lords, your lordships may call it on the same day as that. matter.
20th, 19th.
Very well, very well.
One submission, serial number 56, my lords. Pray for 2 weeks' time. The matter may be urgent for 2 weeks, my lords.
After vacation. 56.
56, my lords.
Serial number 64, my lord. For
61.
Complaints of office objection, 64.
Office
2
of
weeks
will
time.
be given, all 3 weeks time is given.
52 also may be taken up after vacation.
So in all office of objection matters, time is granted for 3 weeks to remove the office objections, dealing with the. at the such
50,
time.
52 may be had after vacation. means.
On the, without to or order of the court, yes.
Serial number
Yes,
62 to 73, conditional order, peremptory order,
Yes,
3 weeks.
yes,
52 may be had after vacation. means.
yes, Mr.
52 may be had after vacation. There is no urgency.
52.
Yes, miss. It is regarding health insurance. I don't want to trouble your lordship now. miss.
So what do you want?
It can be a date may be fixed after vacation. means.
After vacation?
Yes,
After. We'll go to 13th of June.
please, Your Lordship.
Lords, the children have come in this matter. And as my lords, in fact, after the hearing in chambers had expressed my opinion that let the children be here till 31st May is what I understood my lords had in fact
Senior
stated.
counsel.
And
Senior counsel is on his legs in court order 21.
continuous serial.
My lords will call it out in this hearing. In serial.
Great. This seal number 22. The Divya Chase, seal number 22.
Kindly pass over, my lords. Senior is
This matter
here.
is concerned. I appear, my lords, for fifth respondent management. My lords, senior counsel KG Raghavan, my lords, is engaged in the matter, my lords.
But you were not there other day when
Other day,
matter was
Lord,
spent
sir.
lot of time. There was nobody from your college.
In fact, my lords, I was not, in fact, I'm not keeping well, my lords, even today.
You could
Sir,
have told somebody, some friend, if you have any, to mention. We spent lot of time on that day. Again, going like this, waste of time, public time. At least in the first
sorry
court,
I am,
Honorable Chief's Court it is. Somebody should be here.
I understand.
So what is this you are saying?
Lords, senior counsel Raghavan appears, my lords, he's in Chennai right now. He said he'll be on, my lords, VC, my lords.
They will have urgency there
Because of admission.
because of the admission and the examination ensuing on 16th.
Your lords, can I have it, my lords, on
If they have,
16th?
they have no objection, we don't have
16th, my lords.
resolution in granting time.
16th.
Examinations will begin, Mr. Keti, from which date?
Not that the university will be able to say, I will not.
So we take-
Examinations begin from which date?
Lord, that, my lords, I have to get instructions, my lords. In fact, my lords, I spoke to my lords Raghavan, he said, next date,
To seek in education matters,
Please,
the
no, I
first
understand.
requirement is, which is the examination date, which is the
I
cutoff
understand.
date.
I
These are
understand.
the minimum things we were taught.
Possibly 16th somewhere.
16, they said like
They
that
said in
last time.
Lord, we can,
Who is for the
We-
petitioner?
we can actually,
Ravindranath comments.
15 you want? We can keep it on 15?
Should I ask him? Should I ask him?
15?
All right,
Yes, ma'am.
16th, my lords.
15th, because they said examinations begin from 16th,
Please.
somewhere in this.
Please,
But 11 will take.
please.
Just
At 11 will take. At 11 on 15th. In the beginning itself.
11 of the
15th.
clock.
15th.
Lord, may I pass on the, this may be to the benefit of the
Yes.
court. Both the connected matters are. provided.
This is seal number 69. Mr. Lomesh Kiran. Number 69. Contempt matters, seal number 1.
For the
Mr.
petition.
Pradeep Kumar J.
Lords, on temporary registration.
Temporary registration, Lord, there is no provision, only 30 days we can grant. Otherwise, Lord, they can go for a regular registration. There is a provision for refund of, Lord, the life tax paid in the event if they are migrating from regular registration to Bharat series.
The huge investment is involved if it is
Yes,
life
I understand.
registration.
Yes.
Therefore, they are doing that. Because there is an order now.
Yes. Yes.
This you have not put in challenge.
It is
In challenge.
it is
Therefore,
in
appeal needs
challenge,
to be
yes.
held in the matter.
Subject to the result of that, Lord.
You accomplish registration subject to outcome of the writ appeal.
That order we have to pass in appeal. Appeal is there today posted.
Contempt and appeal are posted today.
No, no, we
Appeal is
have
not posted.
against the order of this division bench, Lord, we have preferred SLP before. that.
SLP, where no stay is granted.
No stays.
Are you making that statement that you will do subject to outcome to SL?
Yes. Because
Court order has to.
otherwise let them do regular registration, Lord. We are ready to refund, Lord, in the event of their.
No, that amounts to denying him the benefit of long drawn litigation. But at least you should have moved apex court for taking up the SLP. Not ask him to wait.
On the last occasion, he
It
was
is posted,
absent.
posted on which date?
Lord, on the last occasion, he was absent. That is why, that is exactly for the reason, Lord, it got postponed.
Then don't precipitate the matter.
That's right.
Don't precipitate the matter,
That's right.
so that he also will not be put to any problem.
That is the correct way of. Don't precipitate anything.
Very good.
Since
Don't
SLP
take
is also
precipitate
pending,
action.
contempt is also pending. So maintain a balance
Balance.
by not precipitating.
Don't put him to any coercive action.
We are not initiating any.
No, there is potential danger to him to apply the vehicle on road.
No, without registration, he cannot play the vehicle.
Therefore, we are telling you, you have to come out with some pattern.
Please.
Some pattern you have to come out. You are a state, you are not a private party. You have to come out with some, because how long that matter, as my lord has already said, when SLP is pending, we may not encroach.
When SLP is likely to be taken up?
15th of this month.
15th.
15th.
Then we can.
Lord, may I make one submission?
Then it is a question of 15 days only.
Lord, may I make one submission?
1 week, yes, 1 week. We see that the SLP is.
One submission, just a submission. If I may propose this. Now, my lord, their only sole ground is that there is a loss of revenue, therefore they are unwilling to give the BH series. If he says that the other people also will ask for BH series, I can only speak for myself and my client. We are willing to pay lifetime tax, subject to the outcome of writ petition.
Once the SLP is pending, it will not be.
Generally, it will not be that way.
Proper and will be out of propriety for us to touch the subject matter and pass any order, much less any observation. 19th.
19th. Obliged.
Complainant, my lord. My name is not mutated in the revenue records.
Notice after vacation.
I accept notice for R1.
R1, yes.
Number 3, the Shravan.
Also no notice has to
go. Respond number 1.
You are waiving here also, accepting notice here.
Yes, here also.
My lord, notice may be dispensed to see respond number 3 and 4 and 5.
Election list up for what? Appointment.
Yes, my lord, appointment.
Direction against flood R5 only.
Why you have made all of them as parties, state and others?
Assistant engineer, role.
Notice. There was office objection.
13th of June.
Only for R5 notice. Direction.
You have also role to play. 13th of June. You are for R1.
R1.
4.
My lord, similar matter.
Similar, identical.
5. So why Rajendra Prasad?
For the complaint. They are not complied, the order passed by the single judge. Page number 38. They have to constitute the committee on or before 15/12/2023.
Notice sent 13th June.
I accept notice for R2.
R2.
Where they will constitute the commission. From the date of constitution.
Acha, that is that.
That is that matter, evaluation committee matter.
Ah,
We had made some order.
Yes, like
other day.
similar.
Do you have that copy of
Yes.
the order?
then
Identical order will print
Yes,
here also.
Please.
the committee is not constituted here. Yes, 2, 3 orders. Here direction is also there. Principal Secretary directed to take necessary steps to have the committee constituted on or 15, 12, 20. So this is the direction to constitute. a
To
committee.
constitute, they were not the cases where direction was given to constitute the committee.
No,
The case is a
Where it
bit
is
different. There is a specific direction.
to constitute a committee.
See that it is constituted. You are under contempt. The principal
You have to
secretary.
disperse the application within 6 months from the date of the.
So we'll keep it on 19.
For the second respondent.
Your notice written on 19th of
R2,
this.
R2.
Number 6, Starji Kulle.
So matter may be passed on.
My senior is held up in Kota number 8.
You have complied with the order now?
Yes, yes, Lord. Translate it and produce. in Kannada.
The matter may be passed over.
You can conduct this matter. Notice written. 12th June.
Number 7,
You are for
R3.
R3.
number 7, Stainless Venkata Krishna.
Appear for the complaint. Respect to the page number 10. 11, page number 10. Not complying with the orders of the Honorable Court. With respect to disposal of the appeal before NCTE, National Council for Teacher Education.
Was to be taken up on 8/2/2024.
Please, my lord.
Was not taken up.
Not taken in addition. We have supplied all the copies directed by this honorable court. Thrice we had supplied.
But what is the, these are all members of the committee.
Please, my lord. 3 to
What is-
11.
What is the appeal for?
Appeal for
Admission.
dispo.
Notice.
Please, my lord.
11th June.
So PL matters. Still number 8,
Case I represent
B Vishweshwarya.
interest litigation with regarding breast milk, my lord.
Any specific instances are there?
My lord.
Any specific instances about this?
Yeah,
command?
I produce them.
All theoretical things have you produced, to any specific instances are there?
Any law which regulates this?
It seems
Breast milk
breast milk, it seems.
can
so
be a
far-
property.
Property. It is a human tissue. Look, commercialization, there is no need for commercialization, my lord. Some multinational companies,
That we understand, but any law is regulating in the field. And
it seems
secondly,
so
any-
far.
And secondly, kindly
Yes,
listen, any law, whether any law is regulated the subject matter or the field,
To my knowledge.
and whether any specific instance you are able to come across to demonstrate before the court that this activity is going on.
How court should come to your aid in the absence of policy framework? Any international convention, UN convention, international agreement, somewhere, some framework is necessary. We cannot direct making of law, framing of policy, etc. in PIL jurisdiction.
The operation guidelines and other things have already annexed, my lord.
So your prayer is that immediately pass necessary orders to fully and completely stop the operations of the private organizations involved in the commercialization of the breast milk in any form. So therefore,
Yes,
unless
ma'am.
there is instances, so how can we delve into this prayer?
Now, according to my research, my lord, there is no law as such.
No law, forget law. You are here to lay down law by us. But then where are the instances? It is
Instances.
all,
That is how to rely upon paper reports and other things, my lord.
Newspaper report.
Newspaper reports. I also did a lot of
What is that
research.
newspaper report is which?
Newspaper reports I have not annexed, my lord.
Not annexed.
Yes.
Then
I have annexed the guidelines and other things. Ensuring quality, quality and laceration management, central operation, training.
the subject matter, no doubt important for you to elevate to this level of the discussion in court and relief in court. Otherwise, you go and discuss. Take steps. You bring some better material, then we'll consider.
Then consider.
Yes, ma'am.
10th of June.
How in other countries, comparative
Yes, yes, ma'am.
jurisdictions,
Yes, yes,
in
ma'am.
other countries, what is the position of law?
Yes,
That also you have to.
much obliged.
The question of liberty of contract. We can fear.
Vegetable matters, seal number 9, Mr. Rayappa by.
The appellant, my lord.
You get the respondent.
My lord, this repeal, my lord,
But
the
Hindustan
challenge
Muslim-
the order of the 11th single
So
judge.
leave encasement is to be paid.
Please, my lord.
That too in
Make
only
one
page of
submission,
some
my lord,
order.
before my learned friend commences. In a similar circumstance, my lords, coordinate bench, my lords, had given them some extra time and disposed of an earlier writ appeal. Can we pass on that order, my lord, and if my learned friend accepted, my lord?
Yes, my lord. That's not the 11th single judge directed to pay the EL encashment within the 4 months, my lord. If a reasonable time is granted, my lord, we will consider. my lord.
You are for whom? Company.
I am for the yes, my lord, company, my lord. Because the company is not doing well, my lord. It's a sick company. They are not able to pay the salaries
What you are
also for
showing?
the
Earlier, there was
on-roll
another writ
employees.
appeal.
Ah.
Earlier, writ appeal, some time was granted, my lords, by a coordinate bench. In terms of that order, this one also may be disposed of.
The friend is also saying that
Time.
one.
Yes, my lord. Even he is, last time also, my lord, he very fairly conceded. And this passing.
Within what period you are going to make the payment?
My lord, in the writ petition, my lord, the learned single is granted 4 months time, my lord.
All
With another reasonable time maybe.
No, what is meant by time?
Maybe
We are
under
not here
four-
to
under
define
four-
time.
under 4
What
months.
is your prayer?
4 months, under 4 months.
Another 4 months.
Then you are withdrawing the appeal.
Yes, my lord, we'll. Lordship
Learned
kindly
advocate,
dismiss it.
Mr. So-and-so,
Yes, my
some
lordship
six
may kindly
persons
dismiss
to
it.
withdraw the present
No,
appeal
my lord, I am not withdrawing.
by making,
Lordship may kindly give a direction, dismiss it.
you said yes, then
No, no,
we are
no,
very
no.
happy that you are withdrawing. Well, we'll grant time while dismissing the 3 months time.
And may I pass on that order?
4 months.
4 months.
4 months.
The sick industry.
Please, sick industry. Because it amounts to breaking the seniority, my lord. They are paying this on basis of seniority, my lord. Now because of this, my lord, anyway, we'll try and pay. my lord.
You want to create new norms in the service jurisprudence.
Dismissed with
It is good.
4 months.
From
Done.
today, my lord, 4 months from today. my lord.
Dismissed.
Seal number 10, Mr. K.S.
For the
Bhimaiah.
appellant in this case, my lord, and the appellant company has engaged senior counsel and is held up. I'm appearing for the appellant, my lord. Appellant company has engaged senior counsel and is held up in other court, my lord. Kindly pass over.
Beyond delay is the notice. Delay is the legal notice.
Delay may not be, but
It can be gone down. 13 days delay.
After vacation, you can, no urgency.
some
Immediately
urgency-
after vacation, you will fix a date also. Delay to be condoned.
Meanwhile,
Short delays.
Meanwhile, interim order may be extended.
What
has happened?
Delay of 13 days is explained. In the
Proceedings
supporting
are stalled
affidavit,
before the
reasons supplied make out sufficient cause, delay is condoned.
proceedings before the authorities are stalled because of the pendency of the writ appeal. No question
Shall
of
be
my lord
Who appears
granting
for
any
Labour
interim order.
Commissioner? CGC.
Yes, madam.
CGC for Labour
TJ,
Commissioner.
my lord, what has happened?
BML.
My lord, matter is before the labor authorities, central government. There, of course, the authorities are there.
Interim order may be extended.
My lord, there is some urgency, some date you lost me kindly.
Appeal shall be listed on
Immediately after vacation, convenient date.
7th June.
7th June, we are giving.
Interim leave granted earlier shall continue to operate.
Much.
This will be order in appeal, separate order in IE.
Much.
Seal number 11.
Please.
Mr. V. Anand.
Please. Respondents number 3 and 4 are before this court, my lord. The writ petition was allowed, my lord, by the learned single judge. Lord, they had challenged the annexure G, wherein, my lord, the BBMP had refused to restore the kata in the name of the writ petitioner, my lord. On the ground, my lord, that there is a civil suit pending before the city civil court between the petitioner and respondent number 3 and 4, my lord. It is a suit for declaration and for injunction, my lord.
Which is remanded in that MFA 1880 of 2021.
No, my lord, that is in respect to P&AC proceedings, my lord.
P&AC.
P&AC, my lord.
Was it contested?
No, it was not contested. It was dismissed for non-prosecution, my lord. Then we have filed an application, my lord. P&AC, my lord, we are the daughters of late Anthony Swami, my lord.
Right, which is that OS number?
778 of
778 of 1999.
99, my lord, is a suit for declaration filed by the writ petitioner, my lord.
Yes.
He is seeking for a declaration, my lord, that he is the owner of the property, my lord. And we are the children of Anthony Swami. He claims that he is the adopted son of late Anthony Swami, my lord.
Provided you succeed in that.
Please, my lord.
Suppose if he loses the suit, then he will be paid. You should have been asked to.
But you purchase the property in court auction, court.
The auction purchase.
Decree of
Please.
the court. Decree of the court.
Decree was, his suit was decreed in my favor, my lord, by late Anthony Swami, my lord, in my father's.
Suit is of other party. The suit is of 99 suit is of the writ petitioners.
A writ petitioner.
Writ petitioner.
Writ petitioner.
My lord.
Private party.
Lords, by the order of the learned single judge, my lords, the kata has been restored in the name of the petition.
Notice has to.
Notice, I accept, I have filed my
For
vakalat.
2 and 3.
3, 2 and 3. 2 and 3, my lord.
Our learned advocate, Mr. V. Anand,
please,
for the appellant, notice written on 10th June.
Interim stay of that order.
My lords, may I make one?
Learned advocate, Miss,
Sinchanam.
where accepts notice for this
2
for
and
2 and
3.
3.
2 and 3. But the kata has been restored in the name of the respondent number 3, since there was a direction to the BBMP to do within
Will
4
the
weeks,
status
my
be
lords.
I have paid interim leave. It is directed that the party shall maintain status quo with regard to the Hatha entry in question.
Is it already changed
Yes,
now?
it has been changed, my lords, on 24.
Changed.
Kata has been
Respect to
restored,
the
there is a
property.
direction.
In this
Status with regard to property.
Property in question.
I appear for the appellant in this case, my lord. There is a delay of 56 days. I have given the administrative reasons for the delay, my lord. And I have questioned the order of the learned single judge who has confirmed the award of the labor court. It is a case where, my lord, they were pharmacists and they projected inflated requirement, and thereby they committed a kind of a misappropriation insofar as medicines. It was a group of people, all of them were dismissed from the services.
You're challenging award.
Rejecting all my contentions, the award was passed, granting the full relief.
and it was a group of officials who did this, and all of them were dismissed from the services, including a senior doctor. And these two are the main.
All I noticed.
And I sought for stay of this thing. We will pay 17B wage.
Delay.
The delay
There
is
is delay. Delay the
56.
product bರಲ್ಲ.
We'll pay 17B wages and stay may be granted.
Today there
subject.
is no order except notice.
Number 13, Mr. Chandraya.
Lords, I appear for the appellant. Feeling aggrieved by the notice issued by the respondent to close
Make
down.
use of the mic.
Yes, my lord. I appear for the appellant, my lords. The respondent number 2 has issued a notice directing the petitioner to close down the business which I am running on the score that I have caused pollution. And time has not been given. It was not issued in accordance with law that I questioned before the writ court. Writ court has allowed my writ petition. A condition has been imposed. The petitioner is permitted to use his property for non-commercial activity without causing pollution. I agree that I am not supposed to cause pollution, but go on using for non-commercial activities, it is an embargo that has been issued. I have to use the godown only for the purpose of storing and removing the goods. Without it, I cannot use it. So using the word non-commercial activity is the word which has been caused trouble to me, my lord. So if non is removed and commercial activity, I can use it. That is the reason my client is an unemployed. He has invested the money and constructed in the converted land. Now he is to pay EMI. Under those circumstances, because of the use of this non-commercial activity, petitioner has been made.
Notice to 14th of June.
14/6. Still number 14.
My lord, this
by
is the
government.
government appeal, my lord. My lord, the short question involved is, my lord, the short question that is involved is payment of gratuity, whether it should be from the date of appointment or from the date of regularization. My lord, a coordinate bench of this honorable court, my lord, had
From the date of regularization.
my lord, yes. My lord, according to us, it should be from the date of regularization, but this honorable court held that it should be from the date of appointment. My lord, the coordinate bench of this honorable court had allowed the appeal of the daily wager against which the state has filed an appeal. My lord, I'm producing both the orders. My lord, those orders are stayed by the honorable Supreme Court, my lord. SLP. Single judge, my lord, because
But there is delay.
my
No
lord,
delay.
only 17 days, my lord, the direction issued by the learned single judge.
True, but apex court said in Uttaradi Mutt versus Sri Raghavendra Swami Mutt,
Yeah.
without condoning delay, no interim order can be granted.
Supreme Court has stayed.
Yes.
So then on that day you may notice 10th June.
Obliged. Delay of 17 days.
10/6. Still number 15.
What's the administrator to the petitioner cooperative society is appointed in the month of October. Mandate under the law, that is 28B3, is to conduct the elections within a period of 6 months.
6 months.
Now they cannot.
Election is the ground, but you say that election cannot be a ground.
Lords, it cannot be. Lords, the Supreme Court, while dealing with a matter of the kind, of course, it was pertaining to a constitutional provision interpretation relating to democratic principles. The first of the judgment, Lords, was in 1954 by a constitution bench, which was again subsequently followed by another constitution bench in a
This one
reference.
will be over when?
Lords, it will be over in the month of May.
month of May.
Yes.
Term is
Immediately
still
after May,
there.
we can have this matter because elections are there.
Lords,
Please,
now,
There are some difficulties.
Cooperative society
must-
matters,
they will
similar
be-
matters, my lords have posted post
the
vacations.
only, Lords, if the body which is mandated to hold its term under the statute for 5 years cannot extend a day beyond. Officer who is entrusted with the responsibility of taking over the board under 28A5 and to conduct the elections within that period cannot also hold the board for a day beyond it. What applies to the goose applies to the gander. If that is the mandate with which the provisions are to be interpreted, the same applies. And the language employed may not says, this is how it says. The administrators so appointed shall not continue.
On the next day, madam,
Please,
you
we'll.
ready with the instructions?
We'll take
as to
instructions,
when, yes.
please.
Lords, by now, Lords, this is the whole problem, Lords. Now what they did,
No, they are not going to take any major policy decision because election.
Elections are going and we don't
Code
have
of conduct
staff
is-
not
also,
about,
my lords, to
Lords,
conduct elections.
the requirement, this is a federal society. This is not a primary society. Lords, in respect of a federal society,
Identical question arose in England during the 1939 to
the
45
constitution
war.
bench has,
The apex court, the English court said, almost identical question. When action was contemplated in a time-bound way and war broke out, some bombs fell on London, the House of Lords said, this is an extraordinary situation and therefore, though statute has prescribed a particular period, we have to elongate.
Lords, this is exactly the question. Lords, I just wanted to say this is exactly the question which was considered by the Honorable Supreme Court in 2 constitution bench judgments, my lords. The latest of the judgment
Related
is
to
74.
Constitutional provisions.
Yeah, my lords,
Not
there, Lords,
statutory
the provisions which was interpreted, notwithstanding it was constitutional provisions, but what was considered, my lords, is in the context of the democratic principles. Lords, now, my lords, I am really, lords, where is any question of an officer holding the office, my lords, beyond a period of 6 months, which is not permitted statutorily? My lords, impossibility, my lords, that is the reason. Your lordship said, my lords, now may I just refer to the judgment of the constitution bench, which said, except the act of God, my lord, that is what the Supreme Court says, except the act of God, the mandate of the provision for conducting the elections is not watered down by any other circumstance. The doctrine of impossibilia is no defense. You know, that was a case where three assemblies were not yet constituted. Then they said there is an impossibility because the electorate itself is not full. So therefore, there is a necessity of postponing the elections. Supreme Court said that this is not the kind of impossibility which is arisen, number one. And once the mandate is there to conduct the election prior to that date.
Because apex court said in 2 judgments, in Keswananda and in Indira Nehru Gandhi, that holding of periodic elections is a basic feature.
True.
In the light of that, we have to interpret
Lords,
these
now,
judgments.
Lords, what I am, Lords, only on the democratic
Thanks to
principles.
Society.
Lords,
That
only on the
reduction to
democratic. Lords,
legislative
no,
bodies.
Lords, I just wanted to say this, Lords, it's only on the democratic principles. Lords, now the democratic principles under the scheme of the Cooperative Societies Act mandates the conducting of the elections, Lords, in 2 phases. One, the election is mandated to be conducted before the expiry of the previous term, which they did not do it, Lords, which they postponed on the premise that some provision of the law is not complied with. Lord, that may not be correct because if there is a conflict between the compliance of some procedural requirements, where the period within which the elections are required to be conducted, elections which are required to be conducted requires to be given a precedence. Second is after the administrator takes over under 28A5 minutes, then there is again a mandate that the 6 months is the mandated period. Both the mandates are violated. How many more mandates do they want to violate?
On the previous occasion, please write down. On the previous occasion, in the order dated 18/3/24, the court had occasion to notice notification dated 13/3/24 issued by the government of Karnataka, whereby the term of the office of the members of the cooperative society was extended. And further notification dated 16/3/24, whereby the earlier notification came to be rescinded. Full stop. In view of the above order passed from a learned additional government
AAG, my lord.
AAG, my lord.
Additional Advocate General is Miss
Pratima
Pratima
Honapuram.
shall take instructions
Please.
about holding of election to the
Lords,
cooperative
last
society,
occasion, Lordship said to come out with the dates.
which
They
is
were
al-
required to come out with the dates today.
Immediately,
which is already overdue,
please.
but for the impending
Lok Sabha elections, my lords, in view of the Lok Sabha elections.
Lord, so far as this constituency is concerned, 26th, it will be over.
So we are not
26th
at
of
that
May.
overdue.
26th of April, it will be over. The elections in this constituency, my lords, will be over by 26th of April.
It's immediately
My
after
lords, the reason
vacation,
why I
it
am
is.
submitting, my lords, there is something more than what the eye meets. My lords, in respect of all other federal societies, wherever the ruling party is having its own say, my lords, they have conducted the elections. Belgaum, they have conducted the elections. My lords, in another district, which is the other one? Hassan, they have conducted the elections. No, this is how they do it. When it comes to the question of a society which they feel that this is not coming within, or there is some no political patronage for conducting the elections, indefinitely keep on postponing beyond the period which is permitted. At least your lordships might direct them to fix a date.
Learned single judge has fixed a date, my lords. Within 4/7, you complete.
At least you apply your mind when you are going to.
My lords, immediately, my lords, now 101 ineligible voters notices have been issued, my lords. Immediately after vacation, we'll place on record the
Why not
calendar.
before vacation? As per the schedule is concerned.
Yes.
Statute says 6
Schedule you can tell the court
Please,
before,
my lords.
before vacation, 24th.
Lordships,
My-
grateful for your
my
lordships'
lords, only
indulgence in the matter. my lords.
my lords, only one difficulty, my lords. Now, in view of the Lok Sabha
We'll say
elections.
that on 10 to 24th, on which date learned additional and good general shall come out with the schedule of election.
Lordships.
My lords, 25th, my lords, 25th. 25th, may I request?
25th, 20.
Very well, my lords.
That much you can do.
I will take instructions.
25th is working.
Number 16.
Complainant, your lordships.
I'm submitting the affidavit.
My lord, I may be permitted to hand over the memo of calculation, my lord. I may be permitted to hand over the memo of calculation. This will showcase as to what is the amount to be paid by the respondent, along with the interest. that is
Second,
accrued.
by memo, etc. You cannot go on arguing because money has to reach for client.
Please.
Wait,
So
yes,
I'm
what do you want?
submitting
to
my
say?
affidavit.
Huh?
I'm submitting my affidavit.
What color? Affidavit.
Last day to release.
Have you shared a copy of the affidavit with your
Yes,
friend? Before that only you should give. You cannot give at 11th hour to prejudice
last
our
day.
arguments. Where is your salary slip?
I will attach it. Attach it. Last. 1,48,000 we are receiving at present.
What is the total amount payable in terms of
75
the
lakhs.
order?
Totally 75 lakhs.
75
My lord,
lakh.
there is an interest that is accrued.
This version will come to you. 75 lakh. And other day, what was the submission which we have recorded?
50% we're going to pay.
Yes.
Within 3 months, we're going to pay.
You
within
said
4
that.
years. Yes.
Therefore, we are asking, your other colleague had.
Yes, my lord. Yes.
So where is that DD?
No, after 3 months.
Huh?
After 3 months.
After?
Today, after 3 months, I'm going to
After
pay
3 months.
50% amount.
So for 3 months, the lady and
No,
the
it is
one
only
child,
for
huh?
alimony amount. my lord.
2 children.
2 children is there, this is only for alimony.
Mr.
amount.
Counsel, you
Going to fix
committed
it.
committed before the court for 50%.
Yes,
Now you decide yourself, we don't want to enter into debate. Whether you are going to pay 50% or going to go to jail.
No,
Direct
this is
arrest and
only the-
detention.
Don't play with the court, please.
Now, this is not.
This is playing with the court. Last time you did say that you are going to pay 50%. We passed the order, recorded in black and white.
No,
And you are
madam, we
today
asked on
coming
that
out
day
with
itself and that.
altogether a different thing.
That day itself is 3 months.
No,
we
we will
asked.
not going to
12
toll.
weeks.
We will not
12
going to
weeks we
toll
are
that.
asking, madam.
We are not going to.
That we
Kindly
are-
listen here. Kindly listen here. Look at the court.
They should give-
Are you going to pay? Look at the court, not elsewhere. Not to your papers.
I
Look
only
at the
asked-
court and answer. Are you going to pay 50% as you committed before the court?
After-
Yes or no? We don't want to enter into any debate.
At present, no money, my lord.
Yes,
This is my
we are very
clear.
clear.
At present, we will give you only savings.
Direct his
We are
arrest and
asking for the
detention.
loan
Everything will
also.
happen.
We are taking a loan also.
You were
In
not
3
here.
months, we're going to pay.
Sir, you were not here. You do not know what transpired other day between in the court hall. But we remember. And they are available online also.
Yes.
You are come now, first you have now come. Therefore, I will not say much
No,
more than
that-
that.
that
We
day
will
itself-
direct arrest and detention of your client.
Not my lord.
That's
It
the
is
only
very-
way.
Very difficult to.
She is
arrange
a
the
wife.
payment, 75 lakhs.
2 children,
Big amount.
wife.
Yes, still
daughters.
is 13 years old children. And again, the second marriage are done. We have mentioned all those things in the two after my lord.
You had undertaken to pay.
We are all the
Other
things
day.
we have mentioned. That's why we give me sometimes we're going to pay my lord.
Arrest 75.
Actually, we have to go for execution also. So that is the.
25 lakhs is directed to be paid towards alimony. Now, afferent, what are you going to pay today?
There, okay. At least after by vacation also we can make an arrangement. Some arrangement. we
We'll
have to
pass the
make.
order.
25% after vacation we're going to pay. That is there. Okay. After that.
Yes, come on. It makes no sense because we should be arrested. There should be arrest and detention of such people. That's the only way. That is the only language these people will understand.
That's correct.
My lord,
Lady should go.
we are in meantime is RP also pending is there, my lord.
Very well.
We are required for waiting for that. also.
We don't tolerate blowing hot and cold with the court. That is the first message you should take from this court. In contempt matters, we are not going to tolerate blow hot and blot in that too in alimony matter.
2 children.
Yes, my lord. At least give me the, at least after vacation going to, at least 25% is going to pay that. Otherwise, where will come? So at a day he will come, where he will come.
These things we know, Chief. These things will not run that way. If he were to be some farmer, laborer, we would have understood. He's a professor.
Assistant
This
professor.
case will become. State
Today-
professor.
today
Lakh
what is-
40,000
who
we
is
can
what-
buy, my lord.
Today you are not ready to pay any amount.
He wants
So
to-
today what my lord is not there.
3 months.
At least we can give me then after vacation and some arrangements, 25% we can definitely going to deposit in this court. After vacation.
No, he wants to, for that also time he wants.
No, that will pass.
No, my lord. Only after vacation, immediately we can deposit here. In the court, 25% we can deposit.
Got it. The total amount is payable according to you, how much?
Please, my lord, it is 80 lakhs, my lord,
80
along with
lakhs.
the interest. I may hand over the memo of calculation. as
How
well.
much? 80?
80 lakhs, my lord.
Immediately 75.
75 is order is there, my lord.
50% of 75, he had not taken to make the payment. That's how we did not order the arrest and detention of that day. This is how the things are happening. There should be arrest and detention. Let me challenge that. Where should that lady with children go? To bring children. Let's see.
So 30 lakhs you pay
25%.
within 1 week. Kindly listen.
30%.
30 lakhs you pay within 1 week.
Now, at
We'll
least
keep
we
this
required
matter
one
up.
after
Kindly
vacation,
listen.
4 weeks are required. huh?
Please don't
They have
interrupt.
filed the application.
Please don't interrupt. 30 lakhs you have to pay within 1 week. We will keep this matter on 19th. And on that day, if you are not able to pay, you are going to be.
Don't worry, my lord, we give at least 4 weeks he
On
required.
that day, be ready
Yesterday
to-
they filed,
be ready
Saturday they
to-
filed the application for
After
salary
week-
advances.
After a week.
So
be-
getting at least 2 weeks they required there.
Only-
After 4 weeks,
only-
I'll definitely paying 30.
Only 1 week.
30
Only-
lakhs, my lord.
Only 1 week. And on the.
4 weeks is required, my lord.
And on 9th.
Otherwise, again, the difficulty will cause.
and
4
on-
weeks, at
and
least
on-
we can give me the 4
No.
weeks.
Not at all.
No, 4 weeks is required.
We are not going
You are repeating. You should allow us to do some job.
My lord. Because there is no, yesterday they were to file the salary advance application.
and-
They will promise another 15 days is required. That's why I'm
But
asking
we-
4 weeks.
We are not going to grant. whatever it comes to me.
Otherwise, it would-
Because your
very
because of your
difficult to pay, my lord.
conduct is not acceptable to us.
Very difficult by us, because whoever is there,
On
4 weeks. you can-
5/4/24, comma, the court had an occasion to pass the following order. Then quote the order, learned advocate, bracketed portion. 8/4. Today, when the contempt petition comes up for consideration, comma, instead of abiding by the voluntary statement made by learned advocate for the respondent, that respondent is ready to pay 50% of the amount towards the permanent alimony, comma, affidavit has been filed pointing out about the so-called financial difficulties, and further praying before the court to grant 3 months' time. Full stop. The resilement from the commitment expressed on the previous occasion is to be deprecated. Full stop. The court does not appreciate the shift of change, shift of stand. All of a sudden. Full stop. The order under contempt is about mandating the respondent husband to pay ₹75 lakhs towards permanent alimony to the wife, out of which 30 lakhs each to go to 2 daughters, and ₹15 lakhs shall be paid to the wife towards the alimony. Taking a lenient view today, comma, the court provides that ₹30 lakhs shall be deposited by the respondent husband with the registry of this court within 10 days from today. Full stop. The matter shall be next posted on 18th of April at 2:30. Full stop. On the next date, comma, the respondent husband shall take final instructions about payment of further amount to make it at this stage 50% of the total. From court. Full stop. The respondent is directed to remain present in the court on the next stage. Send over to 18th of April. So on that day, if you are not going to pay,
It's 4 weeks, my lord.
you may go straight to jail from this
My
court.
lord, at least we can, 4 weeks we can grant, at least we can very much difficult to pay.
No.
4 weeks, at least we can definitely, we will take the undertaking also. Within 4 weeks. we
Whatever
to
you want to
deposit.
file to show your
Because there will
bona fide.
arrangement is going on. That's why we are requiring. Again, will same request will comes. 4 weeks will give me at least last, and that day itself you can deposit here itself.
My lord has already passed the order. Everybody has seen. We cannot go on changing the order.
If you can
just
give
by
me the 4
arguments.
weeks, my lord. Then again, the same problem will create.
Yes. What is
For
it?
the complainant, your lordship.
Lord, in this matter, we have preferred an appeal numbered as FR number 571 of.
Make use of the mic. Why lawyers are so weak as their cases are? Yes.
Yes.
At least why should be audible to us?
Yes.
Otherwise, it's a nuisance.
In this matter, state preferred an appeal, my lord, in FR number 571 of 24.
You file appeal?
Please file.
11 years. Is listed today?
No.
To be listed with appeal number so and so and so. On 5th of June.
A copy may be kindly served upon us, my lords.
Give copy between, appeal copy.
Appeal copy.
18.
Appeal with accused lords. The office of actions have been removed. We have filed 4 separate responses to the application.
Page
And,
number 41.
I need my lord's indulgence to file an additional affidavit. Would your lordship kindly grant me a short date, my lord, please? I want to clarify the position of law. No, facts. I want to file a better affidavit in one. Kindly give me some time.
Main matter is still pending.
My lord,
Yes.
yes, my lord.
All the arguments are over.
My lord, what has happened, my lord? What was agreed upon in 2000?
But main matter is still pending.
Matter is
pending, my lord.
heard, almost arguments have been heard.
For the past 2 years, my lord, what has happened is this, my lord. They filed my lord,
It is against 40. Interim order.
interim order, my lord. What has happened, my lord? My 2013 settlement, I am being paid till this day, and no additional salary other than what was agreed upon under 2013. After adjudication, my lord, I have come before this court having succeeded on only the agreed amount. They agreed before the labor court to increase the wages to 2,600.
This can be taken care of at the final.
Well, I will show to your lordship. I'm sorry with the interruption.
Then they filed an
Employ more
application
than
asking for
80%
1 year's
of
time
hours.
to negotiate and comply with the order, 1 year's time.
Many ways to
Well,
compensate.
complaint. I'll show that.
That 1 year's time was also expired, and that IA, my lord, asking for 1 year's time was rejected by the same court, saying that it has become infractious. Now it is 2 years since the interim order has been passed. I'm still on the salary which is being paid under 2013. my lord. These are large number of workers, my lord, and they have adjudicated, they have, after succeeding before the court, they are not even increased by 1 paise, my lord, from what is
I'm
agreed
sorry.
upon in 2013.
Lord, I'm very sorry to interrupt.
In the pending proceedings.
Lord, I
of
will
writ
show to the
petition
court by an affidavit.
7042 of 22, learned single judge passed the following interim order. Then at page 41, from herd to green flap is there and bracketed portion. To learned advocate Mr.
Srinivasan, AJ Srinivasan, my lord.
For the
Complainant.
submits that the aforesaid order is breached, therefore the jurisdiction of this court under the Contempt of Court Act 1971 is invoked, full stop. For the very reason that the parent proceedings of the writ petition are at large for the learned single judge, and the order is interim order whereby no final rights are determined of any of these parties. This court is not inclined to entertain the contempt petition at this stage. Full stop. The complainant, it is open to the complainant to approach the learned single judge in the pending proceedings to work out his rights and remedies in relation to the breach complained of. Full stop. Without expressing any opinion on the merits, the contempt proceedings are not entertained and disposed.
Number 19.
The complainant in this. Complainant in this case.
Yes.
We have filed complaints of it.
Complied.
The copy has not been
complied with, Mr.
He says he has complied with the order, learned AGA, GA.
So we are disposing of learned government advocate, Mr. Mahendra, invites attention of the court to the compliance affidavit filed. Compliance affidavit 28/3/24. The directions of learned single judge sought to be complied with regard to deciding the representation dated 14/3/22 of the petitioner. It is stated in the compliance affidavit that the representation is decided and the order is passed, which is made part of the record.
Document 3 and 4.
Dated
3 and 4.
Which is produced at annexure 3 and 4.
3 and 4.
Those contempt proceedings are closed and disposed.
The copy has not been served. Kindly permit me to.
Give copy to him also.
Nice. Much.
Number 20. So Naveen Chandra.
Here for the petitioner, Lords, on the last day, my lords expressed that the children should be brought here. And till 31st May, since it was submitted by the respondent mother that the Goa school had a break. They should be here. Now, my lords, and then my lords would hear it after in the first week of June. That is what my lords had expressed. Now, my lords, the children are here. My lords, I just want to make a submission that in the school here in Bangalore, the academic year goes on till 12th of June, the current academic year. For 1 week, there is a 1 week break, spring break till 14th. This week, there is a holiday. From 15th, the school resumes. And so my submission would be, my lords, children are here. Similarly, like last time, if the children can be handed over to the father, 1 week there is a holiday. As it is 1 week, they had been taken back to Goa. Let the children be with the father. From 15th, they can continue the school. And then whatever reasonable access to the mother that my lords may say, maybe alternate weekends or whatever, I leave it to my lords. They can see the children and let them complete their academic year till 10th of June, 12th of June, because here, in fact, the school is on. That is in fact, the interim order, my lords, is that till the academic year,
They are
they
already
should.
admitted to Goa.
My lords, that admission is, may I make a submission? That admission, my lords, our submission is, it is in fact not even a confirmed admission. The admission had started, they had filed a writ saying the admission will be cancelled. In fact, there is a petition that they filed and withdrew, saying that the Goa school is threatening to cancel the admission. They have gone there just for 1 week. There, the new academic year has started by their own admission from, I think, 12th of March. They have barely gone there for 10-15 days. The interim order of the Honorable Family Court against which we are here, my lords, says that till the end of the academic year, they should continue. In fact, we have sought for an extension.
Goa
Yes.
vacation is from 8th
Till
to 14th.
31st, no, 31st May.
That's all right. But now also holidays.
No, now my school has holidays for 1 week.
Correct.
In Bangalore.
We are concerned with school of your these children only.
Yes,
Not
yes.
some other.
Yes. In
countries.
Bangalore, there is 1 week holiday.
In Goa, no holiday now?
There is.
There
In
is
fact,
holiday.
in fact, till 31st May, there is a holiday.
I have ascertained, the new notification says that the school holiday starts only from 19th of April.
But 8 to 14, you have holidays.
Plus tomorrow there is, they say.
Only
Gudi
one
Pad-
day, tomorrow holiday. Huh?
Tomorrow there is a holiday.
From tomorrow, completely
No, my
holiday.
lords, again, they have on Wednesday, they have school.
One
And
day.
again, yes, Friday they have school. Until 19th, they have, 19th is the last working day. That is a new notification. The 3rd of June, the school reopens.
3rd June.
From 19th April to
3rd of June.
3rd of June, complete vacation, summer
Yes.
vacation.
Yes, my lords.
What my lords had, in fact, based on the party's discussion, what was informed to my lords was that from 10th of April, what my lords expressed, till 31st May is the holiday there. And that is why my lords, in fact, recorded in the order that the Goa holidays commences on 10th April. That is what my lords recorded in the last date order based on what she has.
Now they say it's not like that. It's from 19th of April.
Anyway, my lords, my submission is that they have themselves, in fact, filed a petition there saying there is no TC, they withdrew, all those things are happening. Children's school year is ongoing. There is a 1 week holiday till 14th here. This coming week is a holiday. 15th, the school.
Today,
will-
tomorrow, holidays.
Yes.
To-
Day
not to-
after court reopens.
Not today, my lords, but with your
Anyway,
lords.
children are here. Now.
Yes, they are here.
Children are
Today
here.
is not a
Yes.
holiday, but they are here.
They are here.
Yes,
On our request.
yes.
Yes.
So today, tomorrow, they are here.
They are here.
And
No.
day after, they have a school.
My lords, one
They have
difficult,
class.
my lords, one difficulty is he was not coming forth regarding the booking of tickets. So she had to book on her own.
We'll reimburse
And
that. That is no
That entire
difficulty.
will be reimbursed, pay
That-
another
yes,
10%
yes.
extra.
No.
Pay another 10% extra
In
also.
fact,
So that
in fact,
Even
the
last time's
reimbursement, there
return
is no
ticket is not
difficulty.
reimbursed.
In fact, last
they will
time.
pay that. They have agreed
No,
to
no,
pay
no,
that.
I'll reimburse. There is no difficulty. In fact, last time he had.
Why
booked a-
long arguments we do not understand?
No.
You said you will pay.
Yes.
They wanted money. Still
Yes.
you want to argue, go and argue.
No, no, I'm only agreeing.
Don't waste
I
time.
have
on
no
that one, please.
difficulty.
So today, tomorrow, the children are here.
Children, tomorrow, she has not, I think, booked the return ticket. I have not ascertained.
Not yet,
They are
want them to come inside. They're outside.
they were, client is outside.
outside. I didn't want them to.
They're standing outside the court.
Come inside. The wife. Outside.
They can come here, inside. And anything is produced to show that they are admitted in Goa school, anything.
Milords,
May I just hand over a writ petition?
Just show something.
Yes. May I just hand over a writ petition to the other side?
Objections itself. it's
Along
already
with
there.
an order
Petition
which
is
they
there, even
themselves
here.
withdrew. Kindly see, my lords, the prayer in
Does
the.
it relate to admission record?
Yes,
This is
kindly
contempt,
see the
writ petition.
prayer at the third last page, page 32. This, the first page is the order of withdrawal. About 3 or 4 pages at the, from the end, page 32, my lords, kindly see. Page 32, the prayer is not to cancel the admission of the children, not to cancel the admission.
When the admission was done,
Let's
you
Take this.
16th of Jan,
8th of
16th, Milords.
And
It is
of
at
January.
page.
And in
page
para
67.
18, they say. They
We'll
start-
come back to you.
I'm sorry.
We'll
I'm
come
sorry.
back to you.
Yes.
Admission was done on 16th of January.
January. Milords, at page 67, your lordships will find it at my reply to the contempt. She got the handbook where it says 19th onwards there.
This is order in transfer petition.
In the transfer petition, that order is made which they have withdrawn in that one.
No, my
No,
lords,
it's not
the
transfer.
order that they have withdrawn, which I have handed over, my
Yeah.
lords, is in a petition that they filed in Goa. Petition starts from the next page. In the High Court in Goa, the prayer in the petition is at page 32, my lords. My lords,
I
will
don't
you see
know what
the ink page 32?
Not to cancel there.
The prayer
today-
at prayer A, it is
withdrawn the
therefore
petition,
prayed
I don't know
for a
what
writ
is
of mandamus.
This
any
has
other-
been withdrawn.
This they
to
withdrawn,
institute a
not,
fresh
and
petition.
here to not cancel the admission, and in para 18 at page 18, for a moment, my lord, at page 18, at paragraph 18 of the writ petition, their own submission is, para 18, the school
no
resumed
recent
classes from 12th
12th of March.
12th
one
March.
minute, in terms of academic calendar of that school. Now, the children have on their own admission commenced classes only from 12th March, which is barely 3 weeks or 10 days, 15 days. Even this admission is dicey because they have not got the documents. Then they withdrew this petition after the court was told that the interim custody issue is still pending. Now, my lords, I have a stable admission here. For 3-4 months, the children missed their school admission and the academic year is still going on. If whatever my lords may decide in first week of June, my lords, they should not be at any, they can, if my lords decide to go to, that they should go to Goa, it will anyway continue. The Goa school has holidays. I should not be in a situation where if my lords confirm my custody of the children, children's school is missed. This school year, my lords, they were already in the academic year from June, July. Let them continue. That's all I'm saying. Children can be here. They can continue, and whatever access my lords decides, I have no difficulty, my lords.
Admission records?
Yes,
that-
my lord,
Where
she
are, where
has.
are they?
Just prima facie satisfied. So they're raising some doubts about your end.
Yes, no, my lord, she has in fact the school.
Are already there, not on record. Yes. One is, my lord, in the contempt petition, if the lordship takes the admission confirmation letter, is there at page 69 in my objection. It's a certificate from the school. Then the payment of fees is there at page.
Do you have the phone number of that school so that we'll ask the registry as to what has happened there?
Yes.
School says. Which is the phone number? We'll request our registrar to speak to the school and tell as to what the school is.
Certificate, not may I just pass this on.
Does it have a phone number of Mr. Nagana? We'll ask our Registrar General to speak to Registrar General of Goa High Court, and Goa High Court Registrar General will speak to the school itself. Everything will be, other thing, by argument, we cannot go on saying whether admitted, not admitted.
That the children are.
Could I submit my
admitted
notes?
here and they are having vacation from night.
That phone number is also there, na?
Yes.
0832-2759.
They're provisionally admitted.
Yes.
Provisionally admitted.
Provisionally admitted.
Yes.
Provisional admission.
And they've attended school also. No?
For the
I
TC,
think
that
that
is.
is issued on in April yesterday.
That was from 24/3.
Well, from 12/3.
12/3.
From 12/3 they have.
No, no.
Because you have said in your petition at para 12.
No, no, that they have withdrawn. I think there was some mistake.
Withdrawal
I
will
think.
not take away what you have stated
No,
to the High
no,
Court.
no, that's right. My lords, I think the school has started, I think, I can ascertain from the mother itself who's here.
My lords, I just want.
Something in camera.
Yes, right now there's.
Up to
vacation.
3rd June, there is a vacation in.
Yes. And
19th to 3rd of July.
yes, I just want to make one submission, my lords. The admission over here where they were studying commenced in July. From July 23-24, they continued till end of November when they were taken away.
No,
That
we
admission
are
is
just thinking-
your.
We are
yes,
just thinking.
Yes,
To make provision for the vacation.
yes.
And anyway, the schools
Thereafter,
will
my
be
lords will
reopened. After
decide.
that, we will hear this matter.
Yes,
and
my
we'll-
lords will decide. I just want to make,
Family court is on an interlocutory application, the matter is before your lordship.
my lords, the
GNWC can be ordered not to be heard. After all, there'll only be two witnesses on either side.
my
It
lords,
can even be finished in 1 month's time or 2 months' time.
my lords, the entire family court order,
Under the audience pact for.
This is only an interim order.
Yes.
My
So that
lords-
matter can be ordered to be heard, my lord, expeditiously. Only 2 witnesses will be there.
No, for vacation, we have to make a
for
provision.
vacation, and my lords,
For
the,
vacation, your lordships may kindly make, my lord, the appropriate order. And then, my lord, by that time, the case can go forward. Get
my
finished,
lords,
not by
the,
time your lordships resume
my lords, I want to make one submission on record. The
That
family-
GNWC is still pending.
GNWC is pending, but there is a stay from the Supreme Court on a further proceedings
On
which they have got.
GNWC.
Yes, now, my lords, the interim order in the GNWC is that interim custody be given to me till the end of the academic year in Bangalore, since the court gave a finding that she has disturbed their academic education. Now, my lords may decide in as soon as the courts reopen. I don't want to be in a situation where children's entire academic year over here is not completed. Anyway, in Goa, there is a holiday. Let them come here and finish the academic year here so that my lords can pass whatever orders at the end of it. Let them, otherwise I myself will be making the order infructuous.
Yes.
There is a holiday there. There is nothing for the children to do in Goa. They can come here and continue their education. Further proceedings,
There,
yes. Yes, in their transfer.
We can.
Honorable Supreme Court has permitted us to process the
Yes,
matter.
yes.
They have brought such an order.
Yes.
So in due respect of that, we are just thinking as to what should be done in the vacation. And we cannot decide the custody matter because matter is stayed by the apex court.
Yes.
Only so far as what should
Interim-
happen
interim arrangement.
now, interim arrangement. That we can.
Yes.
Totally 44 days holiday, vacation is spread over 44 days,
1.5 months.
44 days.
44 days, yes. 19th of April.
Children should also have some break, some vacation from academic work. Because my learned friend says, "Il barli, il school really is there."
3 months they were out of school, my
Quite
lords.
taxing for the
In
children
Goa.
also. They also would need a month's break or so, just having fun.
December, Jan, Feb, they missed out, my lords. They were completely out of school in Goa. This is the school they were continuing, my lords, for last 2 years. Same board. Goes on till first week of June. They can continue it, my lords, and then I leave it to my lords. Whatever my lords may decide.
For this week, children will be here only.
No, as of now, they are only planning for today and tomorrow, Lord, so that go back. But as your lordship may direct, Lord, that they will apply any direct. They may miss 1 or 2 days school.
They can miss, my lords, and stay here.
Staying in a hotel by paying herself is not.
Some accommodation, if they have to stay here, my lord, some provision for accommodation may have
Yes,
to be
yes,
made.
that can be
There are
done.
some service apartments are there, my lord, in
That
the
can be done,
vicinity.
my lords.
That the husband will have to make arrangement for
Yes.
mother's stay.
That can be done.
Allah, my learned friend is saying yes, but not implementing it. That's my difficulty.
We booked the hotels and
We-
they did move
yeah.
some other places.
Contempt may also have to be disposed now. Lordships are inclined to make some further order, then the contempt petition may not survive, Lord, because
let that
the
order
order of
be
the
taken
learned
up to-
single judge
Let us
will
see,
merge
let us
with
see.
your lordship's
Let
order.
us. Please. May survive, but no coercive action may be taken that way.
No, my lord, the allegation of contempt, I have filed writ petition. And in that writ petition, the other side, I'm told, my lord, yesterday we are served with a soft copy of another writ petition filed by them, 24,360 of
Challenging
23.
very same order.
Yes,
That also we have to perhaps, that's before the learned single judge.
but I think,
my
my lord,
lords,
the
in fact,
motion has
listed
been
it-
made and it
my
is
lords
tagged
listed it
along.
here.
In that, my lord, we have to yet file. Yesterday only soft copy is given. We may have to look into that and file objections.
21 to 7. Listed today.
Children were taken to Goa on which date?
26th November, my lord.
26th November.
Yes.
23.
First December.
No, I'm sorry, 1st
First
December.
December.
My
4th
mistake.
December.
1st December.
1st
I'm
December.
She went on 26. on her own.
1st December.
The contempt proceedings as well as the
Please be seated.
contempt proceedings as well as the proceedings of writ appeal. Were further considered by the court with the help of learned senior counsels and the learned advocates appearing for the respective parties. Full paragraph on 1/4/24. The court had an occasion to interact with two minor children in chamber, personally as well as thereafter, along with the parties, their father and mother respectively. It was given out that since children have been studying for the present at school at Goa, at Manovikas English Medium School at Goa, they will go back to Goa. Full stop. Today, the parties as well as the two children have attended the proceedings. Full stop. On being asked by the court, learned senior counsel Mr. So-and-so with learned advocate Ms. S.K. Pratima for the petition for the wife showed the certificate issued by the Manovikas English Medium School Goa, in which it is stated that in view of the subject matter being sub judice, the children have been provisionally admitted to the school. Full stop. It was stated that the children have been attending the classes at the said school. It was further stated that the vacation in the school at Goa, where the children are studying, would commence on 19th April 2024 to last till 4th June 2023. On a deeper consideration of the controversy and the rival claims of parents about the custody and education of children, the court finds that the further interaction of the parents with children and they are staying together may break the ice in the larger interest and future of the children. Since the vacation is approaching in the school, it would be an opportune time for the parties to stay and mingle with their children. In above view, following further interim arrangement is provided for. Full stop. The children are permitted to be taken by the mother to Goa to attend the classes until the vacation commences. During the first 2 weeks of the vacation, children are permitted to stay at Goa with mother at the house where they have been presently residing. Next, the petitioner husband is permitted, unexpected, to go to Goa and meet the children. Full stop. The wife shall permit the husband to meet the children. Full stop. It is expected that all will stay together at Goa. Full stop. Next, for the later part of rest of the 2 weeks, for the rest of the 2 weeks in the later part of the vacation, the respondent wife or whatever wife shall stay at Bangalore. Full stop. You will make arrangement. Full stop. The husband shall make arrangement for stay for the wife to ensure that all
Traveling also.
stay to ensure that all usual facilities to live comfortable life during the stay will be made available to the wife. So the husband shall also make arrangements for transportation and tickets of the wife to come to Bangalore and stay for 2 weeks. Next, during the stay at Bangalore, the husband again shall have right to visit the children.
In my house.
Children will be as your husband.
Children be in my house. The children be with me.
During the whole day. It is okay?
Yes.
And wife will be interacting that with the children.
During the stay, during
only one
the
request.
stay of the children at Bangalore, so the children shall stay with the husband at husband's place. Full stop. The wife shall have right to visit a son at husband's place, and the husband shall allow the wife at whatever time she wants to meet the wife. We meet and talk with the wife.
That should be okay, my lord. Only one small suggestion, my lord. Last time it seems the place where she was staying was at a far distance. So if they can fix up some place in the vicinity, in case in the night she didn't want mother or anything, she can walk across or come short distance.
She didn't want to, she accepted the hotel.
The stay of the wife shall be in the vicinity of the house of the husband. Paragraph. Next, not paragraph. Notwithstanding the above arrangement, it will be open for the parties to stay together at one place and spend their own time. You stay together, what is wrong?
In fact, yesterday also they have gone.
No, we are giving that option.
Yeah,
We are not mandating. We are saying that will be very ideal because children are there.
Absolutely.
That's what weighing.
I
with
think
all-
the
with
children
all
may,
the-
they form the bond.
Yeah, and they have been in school.
For further consideration. Put up.
No, no, school, they have to be in school.
My lords, the school.
Any date your lordship may
Lord,
fix,
my
my lord.
lord.
Be on vacation.
Lords, the school in My lords, our concern is about the school here. It will become a fait accompli that the admission here will be first week of June.
Minor children, my lord has already said they're minor children.
Yes.
Law is heavily bit loaded against husband.
Tenth, please.
Then
Please.
my lord, one more submission. Till my lords have given a two-week arrangement at the moment, but there it may be more than 2 weeks because let them stay till 10th of June here, my lords. After 2 weeks of being in Goa.
They have to go back to school now. 2nd June is.
But it is
3rd
only
June,
fourth,
course,
only
court
3rd or
was
4th.
school
Till then,
reopens.
till then, let them be here till 3rd of June or
The
whatever.
client will add on the reopening of the school. They will come.
Till then, let them be here, my lords.
Entire vacation.
No, no.
No, anyway,
For her-
mother is also coming. Mother is not cut away from the children. 2 weeks they are there. Even now, 1 week they are there. When they come back after 2 weeks, let them be here till at least 3rd of June. Then my lords may list it also at the same time, my lords, so that some decision is taken. We are concerned about the
Station, right, my lord. Therefore,
28th of
28th of May. My lords will list it on 28th.
28th of May, so that we can
And let
decide.
them be here till then.
Huh?
Let them be here till
one or
then.
2 days later, my lord.
Children be here till then.
Please, 30th. Please.
30th.
Till
30th. So 30th is fine, my lords. Let the children be
No,
here
2
till then.
weeks will from 19th of April.
Yes, ma'am.
2 weeks will be over when?
Uh,
14 plus
Give me
11.
my phone, yeah.
6th of May.
5th of May.
So another 3 weeks, they can be here.
Should be, my lord, from 19th, if you take it, this is the 3rd of May. 2 weeks will take us to the 3rd of May.
If it is 3 weeks, what will be the date?
3 weeks means it'll be 10th, my lord, 10th of May.
10th of May.
It is neither.
to 10th.
Till the 4th, 5th May is the weekend. After that weekend, they can come here. 6th to 30th, my lords, is about,
Till 5th of May.
yes.
Please, my lord.
So that it becomes easy for
Please,
all
my
of
lord.
you.
Then after that, they will go back
Then
and,
they come back here. From 5th, they come here.
no. From 19th of April, they will come here, my lord.
No.
They will be with the
They will
mother
be in
only.
Goa. Okay.
Goa. then
They'll come here on the 5th.
They come here
5th,
on
they
the
will
5th.
come here on 5th and from there
Be
3
here till
weeks it will
30th.
be.
Yes.
Till
30th,
30th, they will be with the
father.
father. And your client also see
Please,
and
ma'am.
interact the
Please,
children
please.
for phone, WhatsApp, not much disturbing the, because they are parents.
Please. Please.
And to and fro charges, flight charges you will pay. And for the stay of the wife, if she stays here, that also he had undertaken to pay other day in the in-camera
Only
proceedings.
request that,
It's a good
now that should be
gesture.
done without any hassle, otherwise it'll lead to some bitterness, otherwise again, my lord, we
Suppose
don't
if
want
there is-
emails to be exchanged for
Anyway.
that or WhatsApp messages, that's all.
Anyway, if there is any hassle, if there is
So
any
it can be
tumult
fourth.
created in following my lord's order, then there will be negative marks during the next hearing.
Just one, my lords have said
Last
5th.
time.
They said that the
4th of May.
grandfather's birthday is on 4th. Let them come
4th.
on 4th.
Yes.
So that they can celebrate the birthday of the grandparents.
Very,
That's all.
that's
Only
a
one
good thing.
day.
Instead of 5th, 4th.
Instead of
Please,
fifth,
my
Because
lord.
grandparents are also.
Agbodu,
Father's
no.
birthday.
One set of grandparents will
be
have the benefit,
respectable,
if
be-
the other parents want, they will come,
That's all right.
No,
Be
some-
not disrespectable to each other
please.
and be affectionate to the children. Because the belligerence is only between the couple, not children.
Without prejudice to any of our contentions.
Both of you play the role of mediation
That is necessary.
We have to
and
do that,
settle
my
the
lord.
thing.
They'll make that attempt.
Without prejudice to any of our contentions.
But formal mediation itself, there was a reference, but the other side didn't show interest.
In fact, my lords, in fact, took a lot of effort. My lords only have taken so much effort.
No, we want you to become a mediator in your. You both are very responsible and seasoned.
My lords, we'll definitely take that effort. We'll definitely take
Would it be on 1st June instead? No, it's not troublesome. First, great.
Day and the last time he has not reimbursed, just one.
Please, they will do that. Jenna is here.
Great.
Madam Jenna will do that.
Cell number 69, Mr. Lomesh Kiranian.
Office objections. My lord, if you may.
Lord, I'm
I
appearing for
appear
the-
appellant. If you may request for a short passover, Mr. Holla appears in this. Sorry, my lord. I appear for the appellant. If we may request for a short passover, Mr. Holla appears in this matter.
Very well.
Password.
Tender.
The tender matter.
This is the matter where the order was not.
We are taking up out of turn because the order was awaited and now it is available.
Please, my lord.
Otherwise, there is no
Short passover, my lord.
short password. All right.
Wait.
Cell number 21,
Council for respondent number
this
1.
matter, Lords, I require a short accommodation to file the report on behalf of the amicus. My lords, may I request for it after vacation?
I am for interval applicant seeks my lordship permission to file on the interim application.
This will take time.
My lords, we've
Requires
already
deeper consideration.
If permit me, I will file on application.
Application. Application for?
Application for seeking some directions.
You
No,
shared a copy with
impeding.
your
I
friend.
already served.
Supreme Court has framed some guidelines.
Please, my lords, in fact, the learned amicus has already prepared the report synthesizing all the. My lords, in fact, the learned amicus has already prepared the report synthesizing all the various guidelines of various codes. It has to be placed before your lordships for your lordships' kind consideration. My lords, if your lordships permit me some time, I'll do it in the last week of May, my lords.
Amicus is appointed.
Please, my lords, Senior Advocate Mr. Dhyan Chinnappa is appearing.
My lord, our point-wise, my lord, inputs have been forwarded to the Ministry for Women and Child Development, my lord, in January 2024.
On the day you want, we can take after vacation.
Please.
Madam wants to say anything. Why madam is here?
She's an impleading applicant. She's the impleading applicant party in person.
You are appealing for party?
I can bring it.
I'm very sorry, sir. I had fractured leg, so I cannot stand. My apology. Yes, sir. I'm a medical doctor, gynecologist, and I have experience of 23 years across the world about the child care and development. So with that experience, I bring it on the table to resolve this issue of child custody. And it is very serious issue, and it's urgently important that you should resolve it. And I have a solution for it, bound by law. So we have our own medical law, like, so according to that, every child is a million-year living asset of human generation, bound by law. So we know only how to protect the 100-year-old monument, not the million-year living asset of the human generation. Why it is already documented in the textbooks, basic textbook, school textbooks, universally standard. So it's not my hypothesis, but it is very important that we protect this child, health of the child. That is one thing. Second is that the child, there is no justice to the child. Child is suffering for 18 years, 150 years past, we are trying to help the child because they are innocent. Okay, and we are not able to help them whatever they need. That's why today the PIL is here, and all other countries also trying to resolve it. But they are not able to resolve because the children, they cannot come to the court and say how much they are suffering. And the court has to give the justice according to the law. But the children are suffering. So it is the obvious proof of misuse of power of judiciary. So you are destroying the entire human generation at the grassroots level. And the judiciary has to make use of it in a right way. You have to set it right, sir. Nobody else has the jurisdiction. So I have to explain you in details what are the things going on so that you can resolve this issue and children get the justice. Children need their 18 years. Judiciary has taken it. They say, give my 18 years back. I didn't do anything, none of my fault. I'm suffering every day and night, traumatized by the whole surrounding people. Why me? So give my 18 years back, my childhood, my youth will never come back. So I need my 18 years. How the judiciary will give 18 years? That is the whole issue. We need to discuss in detail who can make the decision.
We will certainly give you the audience when the matter is effectively taken.
Sir, it's not very, because it's very important issue and we need to resolve as soon as possible.
So therefore we want to devote time, not in that cursory way we can take up.
Immediately we cannot do, sir.
Because vacation, summer vacation
For
is fast
vacation.
approaching. So this is a very important issue.
Yes,
We
sir.
appreciate that.
Yes,
But it needs to be looked into with the deeper thought and reflection. Now you have said these things. which
Yes,
are-
sir. All
So
these
we
things
look into
are
that.
entirely different perspective I'm taking.
That's true.
And then
correct.
it is the implementation of it.
We'll give you the audience. We'll certainly give you the
We'll
audience,
fix
full
a
audience.
date so that we'll be highly benefited by your version also.
Yes.
Apart from the council on
Until
either
then,
side.
we will damage and traumatize this living property, sir.
Huh?
The children will continue to suffer. So
No,
we-
therefore, we want to take up this matter on a proactive basis soon after the vacation.
After vacation.
After vacation, some date, because you have to dedicate some time for this.
Yes, sir.
It is
but-
not a run of the mill case,
Yes, sir.
very important case.
Yes, sir.
We have benefit from other countries also.
Yes, sir.
Therefore, we'll look into all that. Then we'll come out with our some.
Sir, but you should, any idea I can give about what I'm going to tell?
Now you have said, you have just,
That
you
is
have
enough?
put the thing, no, it will not be enough. Perhaps you have to, we may request you to
Many
come and
issues
assist
are
us
there.
also. Huh?
23 years of issues.
How she is
I
appearing?
have to bring it on the table, then it will
She
be.
is party in person. Impleaded. She himself is impleaded. If you want to give some bullet points and short notes, but very
Sir,
brief,
but
you
Written
can,
submissions will be
written
very
submission you
great help.
can give.
Sir, it will be, I will give just a half a page.
No, we'll listen to you also, but at the
No,
same
sir.
time, if you want to give
But
some
it will
points.
give misunderstanding rather than understanding. Because it is entirely new subject matter.
You are
That's
there
right.
to
Never heard
dispel,
before.
you are there to dispel all misunderstanding.
It is never heard before. So is there any meeting you can arrange? The judiciary
The hearing only.
authorities?
We can.
We'll devote a whole entire hour or so.
Yes.
And
Whichever date you need, we'll fix that date, which is
Sir,
be
I am ready
convenient.
today also because.
Today we have difficulty.
No, no,
There are
sorry,
many
sir.
urgent matters.
I am sorry.
Therefore,
But just I am saying, I am ready anytime.
any date, whichever you can choose from the pool of dates, calendar.
But whatever date
Tell
you
one
want
date,
to give.
we'll consider.
No, sir. Any date you give me, sir.
All.
As early as possible. Today,
choose-
tomorrow.
Choose any date in the week beginning from
Today,
10th,
tomorrow, sir, no more late. Because
10th,
I'm-
11th, 12th, or
of,
June, 19th June.
No, sir, this month. No.
There is a vacation.
Vacation, so many holidays are intervening.
Okay, sir.
That's the reason.
Fine.
After vacation, any date may be.
After vacation.
And permit all the parties to give some inputs to the amicus curiae, since he is framing some guidelines. Kindly direct all of us to give inputs.
But
Our
give the date which is convenient to amicus curiae also. If any change, then you give any date after 10th of June, you can choose and give to learned court.
And share your versions with madam. So that she will also reflect on that before coming here.
And allow us to give guidelines to amicus curiae. Our inputs to amicus curiae.
Yes, everybody. Collective. Right now 19th, but any change you can intimate the court office.
Let us file my application registration. Please.
Can you?
22 urgent, still number 23. Shivram.
Lords, I appear for the accused.
Thank you, madam. Thank you. Please assist madam for moving here.
Lords, I appear
There's a
for the accused
direction
in serial
issued by
number
this honorable court, my lord,
Undertake to
to
file
dispose of
NOC
the inquiry, my lord, within the particular period. Page 14, my lord, my findings.
Yes. Yes. My lords, I appear for the accused in this case. And I'm
Thank you.
undertaking.
Thank you so much. We'll have it. Will be part of the record. Keep them. Yes.
Page 14 is the order, your lordship.
My lords, I undertake to file
But
NOC.
disposed of
wakalat.
on 12th October 2022.
Undertaking to file the NOC wakalat, my lords. So
Last
a short
occasion,
accommodation may be given.
several times the matter had come up. They took time, my lord, with a view to comply the direction. A small direction issued, my lord, to hear and dispose of the application. Kindly see page
October
14.
22.
How many,
Lords, I don't have any papers. I just got the information this morning, my lords.
how many days they have
Any
taken
date
time,
may
my
be
lord,
fixed,
may
my
kindly
lords.
see. This is the, with great difficulty, I got it posted, your lords. Sixth time the matter is coming up before this honorable. Page 14, my lord, got it, my lord.
of the order?
Not passing order. Direction is to consider. Even
Consider
that
and
we
hear,
know.
consider Have and to go hear. through the papers. Respondent number 3 is directed to reconsider the application filed by the petitioner after hearing both the petitioners as well as respondent number 4 and 5 and pass an appropriate order. This they have taken more than
This was October 2020.
October 22, 10 time matter has come up before this honorable court, 10 times they have taken time. In my absence also, they have taken time.
Bengaluru Municipality. Yes.
My lords, I'll be filing NOC wakalat, my lords. Mr. N.K. Ramesh has given his NOC. So I'd be filing NOC, my lords.
You are not appearing.
No, my lords. This is the first time I'm appearing.
So who appears now on behalf of this?
Mr. S.H. Prashant, my lords. He would be filing.
Where is he?
My lords, he's in other court, my lords.
Call him. Or we call the commissioner. Only
Call the
two.
commissioner.
It may be passed over, my lords. I'll go.
15th at 11. On 15th at 11.
Yes.
This is order of October 2022. What your commissioner is doing?
More than 8
Number
times the
3
matter
is
had
the-
come up.
Number 3, who is number 3? Is direct as well as 4 and 5.
Assistant Revenue Officer, my lord, is required to hear the application. My lords.
3 is directed to reconsider. So 3 is assistant revenue.
Yes.
For assistant revenue. You are there.
Yes.
Yes, my lords. I appear for the accused.
For number 3.
Yes.
Yes, my lords.
Order sheet, your lordship look into.
I don't have any papers. A date may be fixed this week, my lords. Meanwhile, I'll file the reply.
What reply? There is a direction to consider.
The order brought under contempt jurisdiction was passed by a single judge as back as in October 2022. Thereunder, respondent number 3. That's the only respondent hearing. That's the assistant revenue officer. HBR subdivision, Bangalore, BBMP Bangalore was required to reconsider the application of petitioner after hearing the petitioner as well as respondent number 4 and 5 and to pass the approved order in accordance with law within 3 months. Full stop. It is beyond comprehension that despite passage of 1.5 years, no steps are taken towards compliance of direction.
I'm coming on record for the first time, my lords.
If steps are taken, the same shall be put on affidavit to be placed before the court on the next date of hearing. Full stop. Unless the satisfactory paragraph affidavit in that regard is filed before the court, respondent number 3. Respondent is directed to remain personally present. So we are requiring to file affidavit.
Yes, my lords.
Affidavit is found not satisfactory. And nothing concrete is shown about your steps to comply with the directions. On
Please,
the
my
next day, ask him that the court will require his presence.
Please, my lords.
16th.
16th.
Today we are posting on 15th at 11.
16th.
15th at 2:30. 2:30.
Grateful, my lords.
Please.
So number 24.
I represent.
Accused. I beg your pardon, my lord. Kindly grant me 1 week's time and file my compliance affidavit.
The order is dated 22nd of September 2022. But this court allowed the writ petition. The officers are writing, kindly see page 38. After following all aspects of the matter. But I am of the view that the impugned endorsement dated 7/10/2021, Annexure J series requires to be set aside. Matter deserves to be remanded to the second respondent, reconsider the same in accordance with law in an expeditious manner.
Why,
Accordingly,
what
so-
happened to the corporation? Why, what happened to corporation?
This is BDA.
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 Ah, Both they compete with each other in disobeying the court orders.
Pardon, my lord, kindly grant me 1 week.
And the outer limit was 3 months, my lord.
3 months was given in September 2022.
Sincere apologies, my lord. I'll, next date of hearing, the next week, I'll file my compliance affidavit.
Compliance itself you will do. You pass order on that.
Please, my lord. It's direction to consider their, reconsider their representation. I'll file an endorsement, to consider.
You can drop the proceedings. You can take this one and aggravated contempt if they do not, instead of keeping it. It will help you.
That,
Pending, just because my bearing on the senior is.
No, what we do not understand is why BDA, corporation, KIDB. What has happened to them, we do not know. No respect for court orders. We will not say anything about the government till another case comes before us.
Repeated instances
We
here
have to
coming
wait.
across.
These are the,
Repeated instances every day.
Sincere apologies, my lord.
you have taken citizens for granted. That's not the object of our constitution. They are not your captive, your captives.
So on 18th, you comply with the order. Otherwise, unless the order of law on a single judge passed as back as on 19th December 22, which is yet to be complied with, is attended to and appropriate decision is taken by respondent commissioner, Bangalore Development Authority. And the decision is produced on record of the court, the commissioner, Bangalore Development Authority shall personally remain present before the court. You decide, we are giving up to 18th.
If I do not
Up to
file by
19th, 19th. 19th is what?
19th is Friday.
18th. Commissioner Susan shall personally remain present before the court at 2:30.
If he complies, well and good, otherwise let him be here. We want to, we want to take some action. This is not, we are not that happy.
There has to be limit of limit of tolerance. 1.5 years you are sitting tight.
Somebody should be, arrest should happen from higher level secretary, commissioner, minister.
Number 25.
This I appear for complaint, Your Worship.
Lord,
The
this
case
is
where, my
against
lord,
the interim order.
The
Interim order and the writ petition itself is.
The writ petition, my lord, there is an order passed by this honorable court to break open the building, my lord, to keep it open for the inspection. That's
What happened to the writ petition?
the writ petition has been disposed of, my lord, directing break open the premises, my lord. I am before this honorable court, my lord. That was
Interim order.
yeah, that was decided a day before last week only, my lord. The main matter came to be disposed of about a week back only, my lord. This contempt is arising out of an interim order, Your Lordship. Interim order, what has happened, Your Lordship, in violation of the order undertaking given before this honorable court for a moment, how high-handedly the officer has acted, my lord, notwithstanding the disposal of the petition.
No, you should have told the learned single judge.
Yes, Your Lordship.
They are doing like this.
I stated
So put them behind the, that
no,
you should have told.
no, everything I brought to the notice of the court, Your Lordship.
Now final order is passed in the
Final order has
WP.
been passed, Your Lordship. No,
Against you.
No, in my favor, my lord.
And put that order in.
No, directing, my lord, to break open the alert floor mill and keep open for the inspection, everything, my lord, they passed the order. All that time concerned on the limited point.
No
Your
case
Lordship.
is made out for exercising contempt jurisdiction. In this case, for 2 reasons. Firstly, the order is interim order passed by learned single judge. Secondly, admittedly, the main proceedings of writ petitions are disposed of, having ended in the favor of the complainant. Dismissed as not.
Obliged.
Number 26. The Ramurthy HS.
This case time for complaint.
Yes.
The single judge minutes, given a direction minutes, page number 11 minutes. Direct to respond number 4 and 5 to conduct the Code and Duress minutes.
Code and Duress.
Code and Duress minutes. I have made a representation minutes on 2015 minutes.
Where is it?
within 3 months. Was
Three
it done?
within,
Kodi
out-
Durasti done?
No,
Not done.
Not done. Because it's within 18 kilometers from Bangalore. 108K, there is a prohibition.
Correct, but order is not put in challenge.
Yes.
That contention could have been taken in that matter,
Yes.
not in justification of violation of the order.
I understand. Yes.
So what will be done?
So in the manner law, it is said in the manner known to law.
Yeah.
So you can cite that reason. We are not here to
Please,
evaluate.
2 weeks time may be granted, Lord, by that.
So we dispose it.
2 weeks
2 weeks.
to take whatever you want to do.
In accordance with law, Lord, will
While setting aside the endorsement dated 19/12/22, which was impugned in the writ petition, learned single judge directed respondent 4 and 5, conduct Kodi and Durasti of the land of the petitioner in the manner known to law within a period of 3 months. Full stop. The above directions are brought under the contempt jurisdiction of this court. Paragraph. When the contempt application comes up for consideration, learned government advocate Mr. Mahendra, upon instructions of the officer present in the court, makes a statement that the appropriate decisions will be taken by the competent authority within a period of 3 weeks from today. The above statement made by learned government advocate satisfies the complainant who appears through learned advocate so and so, so and so. Full stop. Any of the above statement made before the court on behalf of the authority, the contempt proceedings are closed and disposed of. However, it is observed that non-adherence to the statement and non-compliance of the directions of learned single judge within the time stipulated above shall expose the authority to the aggravated form of contempt.
Number 27, Mr. Mohan MS.
Petitioner is.
I undertake to appear on behalf of accused number 1. Lord, may grant me 10 days time, Lord, I'll do the needful.
Order
I'll
passed
come
on
back with
6.
him, Lord.
This was December 2022.
Please, Lord, may grant. Rest other two.
What has happened to BDA? Why orders are not complied? Why so many cases we are spending on contempt matters?
But we have, now the present commissioner has expedited all the issues of the earlier clearing of all the consideration of the representation. We are doing it, Lord. We are in the process of completing all those. But what some of the lack of communication with some of the departments was an issue. Now it has been sorted out. All CCMS has been put on place. But the officers will be directly informed through CCMS only. What was there in the state government, Lord, is now been implemented.
We do not know we are on this order.
Yes, yes. Lordship may give.
Really, we don't want. Whatever you want to do, you do.
Yes.
And we are making you to do, believe us.
No, yes, I'm not, we are bound to do, Lord, we will do it, Lord. Lordship may grant me 10 days time, Lord, I'll by then, Lord, I'll
What will
see
do
that
within
the
10
order
days?
of the learned.
Comply with the order and
Comply with
Lord, I'll report compliance.
learned advocate so and so stated that the order under contempt shall be complied with before the next date.
Please.
Put upon 22nd of
Oblige. Please,
April at 2:30. For reporting of the compliance.
Number 28, Mr. Subramania Bhatia.
For the complainant in this case, my lord, the
Complied.
compliance report is, affidavit is served on me, my lord, today, but there is only one submission I would like to make, my lord. There is a delay of 2 months in complying the order, my lord. In this time, the complainant did not receive any
They have
salary.
complied, though there are interim orders now. Even otherwise you would not have interfered. There is compliance now. If you are aggrieved, you take up
I'm
matter
bringing-
in appropriate proceeding.
Please, my lord, I'm just bringing to the knowledge of your lordship, that's it.
He is also reported for duty. Learned advocate Mr. So and so files compliance.
Compliance is in their favor, in your favor.
Which could not be disputed by learned advocate for the complainant. However, she stated that there is a delay in complying with the order. Whatever grievance survives in respect of the act of compliance, it could be agitated in a separate proceedings. These contempt proceedings are not liable to be continued any further. they are disposed of accordingly,
Very well.
has not survived.
Great.
Seal number 29, ready in notice matter.
Appearing for exponent 4 and 5, my lords. Lordship, this is a matter wherein we had sought for directions as against the Election Commission for formulation of certain guidelines. Lordship, with respect to the elections, we had also brought the attention of this honorable court. At the previous state elections, Your Lordship, there are a lot of discrepancies that were not addressed, and therefore we had asked for specific formulation of guidelines. What the EC has now filed statement of objections. They've given details of all the other areas in which they do take some kind of preventive measures. If Your Lordship looks at them, most of them are all post-mortem measures. There are absolutely no preventive measures taken by the EC in order to curb the issues that we have raised, Your Lordship. And there's also an admission by the EC in their objections in paragraph 11, where they've admitted that they recommended closing of the case against one of the persons who had violated most of the issues, stating that there are other criminal cases pending against him and therefore it could be taken up. And they have also admitted that in view of the fact that there is any absence of any legislative provision and therefore they have not. But a comprehensive guidelines which they can do, they are not willing to.
The freebie issue is pending before the apex court now.
Freebie issues, please. That is pending before the apex court. Here, the issue is not just about the freebies or cash for money, which we had also raised. The cash issue, Your Lordship, and we've also raised this in our prayer because now technology has reached a stage where they're able to circumvent a lot of provisions that are already there. The previous elections, there were open distribution of money, cards where there are money which could be encashed, all of that. And whether the Supreme Court decides on what is to be done, which has gone to a larger bench. Here the issue is with the EC, Your Lordship. Most of the complaints given to the Election Commission in the state here are not addressed. And they say anyway representation of People's Act is there, IPEC is there, you can file cases there. Your Lordship, all of that is a post-mortem exercise. What they're doing to prevent it, they have not come up with anything, Your Lordship.
This will be interacting with the what is pending.
That would
My
be
lord.
on the issue of whether
My lord, I am
freebies is
appearing for the
permissible.
respond to election commission, my lord, of filing my objections. My lord, it is not that we are sitting still.
Served copy.
Served, my lordship. We are not sitting still, my lord. My lord, lordship, we have produced a statement. Lord, during 2023 elections, we have seized, my lord, 384 crores my lord, worth items. And during, as on 4/4/24 in this election, my lord, we have seized 187 crore rupees and cash and items, my lord.
187 crore.
Yes, my lord. I produced at annexure R4, page number 41. My lord, this is a table. Seizure of the items, my lord, during the 2023 general election to Karnataka Legislative Assembly. At page number 41, my lords will get, my lord. Figure is at the bottom of the page. Right side corner of the page, my lord. At the bottom right side corner, my lord.
153 crore.
My lord, before that,
Item number 1.
I request, my lord, page number 41.
41 only.
Lord, at the right corner, my lord, the total figure is there, my lord, 384 crores.
Totally 384 crore worth.
Please, my lord, money and
material.
Money, liquor, drugs, my lord, and material also. Lord, in next page.
Whether
number,
cases are also.
Lord, cases are registered, my lord.
Registered also.
Registered, my lord.
Where have you stated?
My lord, that I have not stated. I will state, my lord, what happens, my lord, in every seizure, my lord. Lord,
Not
they are
necessarily a
registered.
case.
My lord.
Every seizure need not necessarily result into registration of a case.
My lord, the instructions are in the commission, my lord. With my instructions, my lord, they have cases are being registered. No, my lord. At page number 42, my lord, this is the present elections. Lord, as on 4/4/24, Lord, we have seized 187 crore.
Around 87 crore. After seizure, what are you going to do with that seized material and seized money?
My lord, their release of the mechanism for SOP for my release of the amount. Lord, if the amount is more than 10 lakh, my lord, matter will be given to the income tax department. There is a SOP is already in force, my lord. Lordship, for a moment, Lordship, can you turn to page number 30, annexure R3. Lord, relevant page is page number 32. Lord, this is the order made by the Election Commission on 29th of May 2015. My lord, unnumbered third paragraph, my lord, in the first portion of the page, my lord. Sentence begins with now. Page number 32, my lord.
Now therefore.
Please, now therefore, for the purpose of maintaining purity of elections, the Election Commission of India hereby issues the following standard operating procedure for flying squads constituted for keeping vigil over excessive campaigning expenses, distribution of items of bribe in cash or in kind, movement of illegal arms, ammunition, liquor, and antisocial elements, etc., in the constituency during election process. My lord, we have constituted 2 squads, my lord, flying squads, and my lords, the detail or the working of the flying squads are detailed in the next pages, my lord. And another is, my lord, static surveillance team. Now, my lord, apart from that, we have come up with the mobile app, my lord. The details which are, which my lords get it page number.
The release of cash is at page 36.
Please.
This is the protocol.
Please, my lord.
Para 16.
Please, my lord. Apart from this, my lord, we have come up with the mobile app. Lord, it's called C Vigil. Lord, even a citizen can upload the capture a photo and or the video and upload it on the that app, my lord. It will message will send to the concerned static surveillance team of flying squad. Lord, within 100 minutes, my lord, this team will arrive. Within 20 minutes, my lord, the team will arrive in the spot. They will take the action. My lordship, may kindly turn to page number 93. My lord, we have started with this C Vigil app since July 2018, my lord. Page number 93, my lord.
86 and then user manual.
And now, my lord, the features of that app will, my lords, will find at page number 100. My lord, it's a foolproof app, my lord.
What is the response of citizens?
My lord, I have produced, my lord. Now, my lord, in this election, my lord, since the 16/3/2024, Election Commission has announced the elections. Lord, so on 11/3, I'm sorry. My lord, as on 29/3/2024, my lord, page number 104, annexure R10. Lord, this is a press note released by the Election Commission. My lord, from 16/3/2024 to 29/3/2024, we have received 79,000 complaints on C Vigil app.
99% have been resolved.
Please, my lord.
You also go through all that.
Please.
It appears actions are initiated and orders have been issued under Article 124. And they are all statutory orders. Even their violation amounts to offense also. That has been upheld by the apex court. Therefore, just look into all these things. With this, we observe if we dispose of, it should not give any wrong impression to any of the sides. Therefore, we'll call this matter immediately after elections.
You produce all circulars and orders.
My lord?
All circulars.
My lord, there are some, my lord, in the, we issue directions, my lord, instruction in the form of handbooks, my lord, and orders, my lord. Some of I produced.
Only
handbook for the police.
one you have produced, one.
Give full one set of handbooks.
My lord, for
so that we'll look
my
into
lord,
everything.
I will, my lord, what happens, my lord, it's 100, 200 pages. I will place it on.
On the subject, produce all.
Please, my lord, I will.
Might I only draw your lordship's attention to the same objections that they've filed in para 6 and para 9, your lordship. In para 6, what they state is that the absence of any legislative provisions, Election Commission exercising power under Article 324 issues instructions, guidelines for effective discharge of its constitutional duties. These instructions, guidelines are in the form of letters, manual, handbooks. So there itself, they are stating that under 324, but they do not have any legislative provisions, and therefore they're trying to state that for them to take any action would be difficult. But what is most important in paragraph 11, if your lordship may kindly see, we had brought out only one instance, so as to show your lordship as to what is transpiring. Lordship may kindly see, this itself shows what the EC is up to. In paragraph 11 and page 5, your lordship may kindly see that an FIR is lodged in 10-5 was lodged against Iqbal Hussain at Ijur police station. It was further stated that 2 election petitions and EP had been filed challenging the election of Iqbal Hussain before this honorable court. Furthermore, as recommended by the Chief Electoral Officer, Karnataka, the complaint was closed on 17/10/2023 in view of the pending FIR and election petitions mentioned above. This is a very convenient way of absolving a person of all his errors and illegal acts that he has committed, stating that FIR is pending. Your lordship, what happens
No,
is
my lord,
that...
lordship may kindly consider, we are not the prosecuting agency. My lord, Election Commission will issue instructions where the law is not occupied. My lord, as my lord's evidence, CH-1 versus AC Joseph Shivan Pillai, 84 Supreme Court. Now, my lord, if the commission of the offense, my lord, it is satisfy the requirement of this statute, my lord. Lord, we can't say we issue further instruction in supplanting those legislative provisions.
But
Now,
why you recommended for closure of the case?
My lord, we have not recommended closure of the case, my lord. We have closure only the complaint of the first petitioner. My lord, the FIR is pending, my lord. The police have taken initiated action. If FIR is registered, my lord, I have produced that FIR at page number
Where
25.
is that Chief Electoral Officer's recommendation?
My lord, at
Page number?
Page number 20, my lord. No, it is not recommendation, it is a response to of the Chief Electoral Officer to the letter of the Election Commission, which my lords find it page number 19.
At page 21, he says, I am directed to submit that the above complaint may be closed.
My lord, complaint may be closed for taking action on the at the hands of the Election Commission, not at the hands of the police.
We are not making police a party or
Lord, when
whether
a
election-
legislative action, then the police have taken the statutory action, my lord. We can't, there is nothing for Election Commission to do further.
Your lordship, this is a classic example that we have stated where people like
What
Iqbal
was
Hussain-
the offense that was allegedly recommended to be closed?
My lord, that is the distribution.
What was the offense and what is the, whether nature of cognizable offense or non-cognizable? Because law has developed in that direction. If these are the offenses enlisted under chapter 9A of IPC, then there are many constraints.
I understand your lordship.
My lord,
This is a
we have
matter
taken-
where even
I'm
with
sorry.
videograph proof, we had stated that they have even made barcodes in the cards. So most gullible people are believing that these are encashable cards. And he has in a video stated, I'm aware that a lot of you didn't get the 2,000 rupees which you were supposed to get in the card. I will give it to you later.
You
all that
produce
complaint is made after election.
compendium.
Please.
We want to look into before.
Now, my lord,
as
that
said.
complaint is made after election. That is on 27 July 2024. Lord, lordship may kindly at the FIR 28, page number 28. Lord, permission has been taken from the magistrate. I mean, thereafter FIR has been lodged.
In respect of the very same offense.
Lord, that is the offense which the learned senior counsel is referring to.
No, why your chief electoral officer recommended a closure of the criminal case is a little
My lord,
bothersome.
criminal in the sense, my lord, it is not in the English is not correctly worded because he says the intention of this letter closure from the action by the Election Commission, not by police. Since police has been filed the FIR and 2 EPs are pending before this honorable court, therefore he is recommended for commission to closure of the matter, not from the hands of the commission, not from the police authorities.
At the level of commission, you said.
Please,
closure.
please, my lord. That is the intent of the letter.
Election
Not closure of the
No,
criminal case at all.
No. We have
Where-
not.
Where is that?
My lord,
Where-
page
where
number
you dealt-
21.
Where you have dealt with this aspect in your reply?
In your reply, where have you dealt with all that?
My lord, in my reply, my lord, that I have not gone to in that specific. My lord, I will file my lord better affidavit. Lordship may kindly.
You mean to say those criminal cases were not closed, it cannot be closed also when they are pending before the court?
Please, ma'am.
At the level of commission, we will not do anything, is
please,
your
ma'am.
lordship.
That is where the
My
problem
lord,
arises.
at paragraph 11, that is
Recently.
my lord, so my lord, so I asked where I have written, my lord, paragraph 11 in page number 4 begins, my lord. Bottom of the page number 4.
Page number?
4, my lord, of the objection statement, my lord. Paragraph number 11. I read, my lord. At the bottom of the page 4, my lord.
Yes, that's we have read. Because of that, we are asking this question. Since there is no clarity now which you intend to
My lord, my
make
lord,
clear
I'm sorry,
across.
my lord, but it is the intent of the letter of the chief.
Is closer at the level of the commission because matter is being investigated into by the police.
Please, ma'am.
And election petitions are also pending.
Please, ma'am.
Where the identical issue,
Yes,
the
ma'am.
corrupt practices were grounds of election petition.
Please, my lord.
And in an election petition, if this honorable court holds that it is in favor of the election petition, the petitioner, ultimately the second candidate would survive. Your lordship, if this matters kept pending during this, the reason being, again, they would only come up with corrective measures or something that could be done at a
Anyway,
later stage.
this is in respect of the assembly elections already completed in.
Your
20.
lordship, that would be on
My lord, these
whether
petitioners
those
are
freebies are
unsuccessful candidates in the
maintainable or
election.
not. This is only with respect to why the election commission has not so far done anything to take preventive measures instead of, your lordship, if an FIR is pending for
So
10
what
years.
preventive, where is the staff? Our constitution does not permit the staff to the election commission.
Your lordship, that's precisely their guidelines, your lordship, where they come about. In the guidelines itself.
They
if-
have squads,
under-
flying squads, and they have district election officers, local inspection officers, surveyors, a host of officers and the personnel are drawn under section 28 capital.
Please, my lord,
A.
even if we appoint, my lord, as observers, senior IAS officers, these are officers, Lord, will be observing the functioning of the officers and report to the election commission.
The election commission does not have staff at all.
Lord, except with the 3 commissioners, we rely on the staff of the state government, my lord.
Correct, and that's where the problem arises. The staff, your lordship, would be, that is why when code
And
of
those
conduct is
staffs are
announced on
on,
15th,
deputation
on
to election
14th,
commission during election
conveniently,
period.
the transfers are made where the state government finds people who are conveniently in their, the thought process, and those people are placed.
Put up something more. It is.
Your lordship, if it may be taken before since the elections would be during the vacation time, your lordship, if it could be taken just before the end of the
No, they
starting
have-
of the
they have-
vacations.
In fact, we wanted to dispose of the proceedings, but since the elections are imminent.
Yes.
Please,
Therefore,
please.
we are not passing any
Obliged,
orders.
obliged.
So
Liberty to move if there's,
13th, liberty. to-
liberty to move the court if there is any of the issues that arise during the pendency of this.
It is always there. Why?
Please.
My lord, instead of only side, let them move the matter. Instead of,
Will not pass order because the newspapers may interpret our orders in their own way, which we don't want.
Obliged.
Which-
Number 69.
Appearing for the respondent in this matter, my lords. In fact,
Lord,
Yes.
rejoinder, my lord, because what has happened is they did not file objections, my lord, at that time, when the writ petition was pending.
They filed, my lord, objections, my lord, before your lordship in the writ appeal. Therefore, my lord, some rejoinder is needed.
Rejoinder.
Objections they have filed now. What happened was, my lord, when during the pendency of the writ.
Single judge they had not filed.
No. Huh? Sorry, my lord, I stand corrected, my lord, I'm sorry.
Papers
My
are
apologies.
there
No,
where
they
objections are
did file,
filed.
they did file, my lord.
Filed.
Then what is this?
In fact, we have filed our objection before the
That's all
single
right, I
judge. my
stand
lord.
corrected, my lord, no. This is.
Filed.
They had filed
They have
rejoinder
my
before the
lord.
single
Sorry.
judge also.
What is this rejoinder? That's all right. Rejoinder to the, my lord, they have filed objections in the writ appeal, that for that, my lord, rejoinder. My lord, what has happened is,
Yes.
a contract tender is invited, my lord, for 8,000 crores by the Karnataka Power Corporation Limited. Estimated value, my lord, is 8,000 crores. Can I, my lord, pass on one list of dates, my lord, for my last?
But
Period of the contract is, sorry. Serial number 3, my lord. Estimated value is 8,000 crores. Period of the contract is 5 years from the date of handing over the site. Last date for submission of the queries is 9/2. Date for pre-bid meeting 14/2. Last date for submission of the bid documents, my lord, is 21/2. Environment clearance and wildlife clearance, my lord, is yet to be obtained. Pursuant to, my lord, the NIT, prospective bidders, my lord, sought clarification in respect of, my lord, 270 queries. Reply to the queries, my lord, was on 17/2. And many other queries, my lord, not answered. Corrigendum was issued, my lord, they extended it, my lord, by 2 days to, my lord, 23/2. Project involves, my lord, construction of a pump storage, substantial portion of civil work, my lord, which is underground. In addition, my lord, it also involves, my lord, tunneling of mountainous terrain to a length of about 15 kilometers, comprising of, my lord, tail race tunnel, main access tunnel, cable access tunnel. The geotechnical report, my lord, is essential. It, my lord, provides, the report itself is incomplete. My lord, this is within the Western Ghats. So, my lord, the geotechnical, my lord, report, my lord, is needed. That is wholly incomplete. In fact, my lord, geotechnical report, serial number 8. From, my lord, these stretches of the race tunnel, my lord, and the main access tunnel were not complete at all. All the bidders, my lord, sought for extension. Now what has happened is, they have, my lord, given this award, my lord, after the order passed by the learned single judge to, my lord, 1 mega. They have paid, my lord, 100 and odd crores. We have stated that also, my lord, in our writ appeal to, my lord, the party in power. And, my lord, the award has been given to them. In this case, my lord, what has happened is, Section 7, my lord, Rule 17 of the KTPP rules specify that, my lord, there has to be, my lord, reasons for, my lord, if they have to, my lord, give a my lord, they have to give a minimum of 30 days. Not, my lord, can I persuade your lords, just look at, my lord, serial number 14. Effect of, my lord, various, my lord, similar projects, 200 days to 120 days, my lord, were all given. In this case, my lord, within a matter of 1 day, my lord, the technical report, my lord, is accepted. The financial bid is opened, and, my lord, the entire thing, my lord, is completed.
what is the wrong with the impugned order?
My lord, what has happened is,
What
my
are
submission
the-
to your lordship says, my lord, that, they have to give, my lord, sufficient time for, my lord, a study or the technical, my lord, evaluation. I mean, sorry, the geotechnical survey. Geotechnical survey itself, my lord, was not complete. This is, my lord, a project where, my lord, it is in the Western Ghats. My lord, there has to be, my lord, a study conducted by, my lord, the various bidders. The geotechnical study, my lord, even according to the, my lord, which they have submitted, my lord, is not complete. In respect of the tunnels, my lord, we have to do this tunnel underground in the mountainous region. That has not been, my lord, looked into at all, my lord. The geotechnical report, we have placed it before your lordships. That geotechnical report, my lord, specifically says the tunnel reaches, my lord, they have not, my lord. Please. Very well. Only thing is, my lord, here, now they have given it to a bidder. One, my lord, they have selected that bidder. We have filed an application, my lord, for impleading him also, because without hearing him, my lord, it can't be done.
That notice has to go to that bidder.
Yes, my lord.
But this matter will be subject to.
If I may request, my lord, we'll see that they are served also, my lord.
Very well. I have no problem.
Your lordship may have it, let them take out hand.
Lord, in fact, may make a submission.
I think he is
But
trying to
Lord,
take notice.
For
Lord,
the.
Lord, yes, Lord.
Very well.
Successful bidder.
Bidder
Please,
now,
please.
very well.
You are appearing.
Then, my lord, we'll serve a copy on him.
Very well.
The formal notice and then.
Yes.
16th or 18th, whenever.
16th is a half a day, my lord.
So you allow the impleading application.
Pleading
Please,
application
please,
will allow.
please, please.
So that we
Lord,
can
I may also be
argue.
permitted to file my statement.
On 15th, 16th,
Please.
when?
15th.
My lord, 15th, my lord, I am not in town, my lord.
16th?
16th is better, my lord.
All right, 16th we'll have that. 16th, all right.
Please.
16th is all right.
Office objections, my lord.
On top of the board, my lord, if possible on 16th, my lord,
No-
because it's a half
no
a day.
problem.
We'll
On top
keep
of
it-
the board.
Whenever we keep, we'll keep it on top of the board. Or at least
Please,
2/3.
please,
Please.
To the 18th then. 18th?
Very well.
18th.
please, my lord, please.
My lord, some office objections are there. We have amendment application. What has happened is, we have to, my lord, the office says, my lord, we have given a short form, my lord, like we do in the writ petition. In the writ appeal, my lord, long form of affidavit. Wonder, my lord, whether.
No, issue. We can consider along with the main matter.
Very well, my lord, very well. Please.
Heard learned counsels for the respective parties. The applicant herein, which seeks to implead itself in the proceedings of writ appeal, is the AOD of the tender. To stop in the main proceedings, it is the tender process which is called in question. In that view, the applicant herein can be said to be well interested in the outcome of the writ appeal. He is proper and necessary party. Accordingly, applicant is permitted to be impleaded as party respondent in the writ appeal proceedings. Present application is allowed. Post titles will be amended accordingly. And fresh copy of the
Please. We'll
appeal
serve it.
memo
We'll serve it
shall be
immediately.
supplied
Late.
before the next date, put up on 18th of
Interim order, I think, my lord, your lords are granted to be continued.
18th of April.
Please.
Also. Since the interim order was earlier granted, it shall continue till the next week.
Please.
Please, grateful to you.
Number 78. Withdrawal of contempt.
Matter we have complied. They have complied also. But anyway, they want to withdraw.
Memo is filed. Any of the memo of withdrawal dated 1/4/24, whereby the complainant seeks to withdraw the present contempt proceedings. It is stated in the withdrawal memo that the respondent has complied with the order dated 26/6/23 passed by the court in writ petition number 721/23. Dismissed as withdrawn.
Lord, item 61, I appear for the appellant, my lord, which is a state electricity utility. There is some urgency, my lord. There's a direction given that we should give open access for electricity being generated in the state. So, my lord, could your lordship direct it to be listed on the next working day, my lord? There's some urgency, my lord. Urgency is this, my lord, that pursuant to this order, large number of generators have written to us to say, we don't want to use power energy to state, we want to send it outside the state. Because section 11, my lord, there's an order in operation.
Now beyond vacation.
Not some urgency, because this is a crucial time. This order itself is valid for summer, my lord. I'm only requesting that, my lord, it may be taken up, my lord, because based on this order, we have received large number.
All right, 19th.
19.
Great.
Serial number 31 on date.
All dates will be given.